I am J.D. Solomon, Chairman of the Environmental Management Commission. It's 9 o'clock, and I will call the May meeting of the EMC to order. First order of business, North Carolina General Statutes 138A-15 mandates at the beginning of any meeting of a board, the chair shall remind all members of their duty to avoid conflicts of interest under this subchapter. Chair shall also inquire as to whether there's any known conflict of interest with respect to any matters coming before the board at this time. Do we have any conflicts of interest? Okay, hearing none, we will move on with no conflicts. We do have a quorum today. I was called by Commissioner Gibson to say that she has, she's sick, so she won't be here today. I told her to take care of herself because it's that time where things creep up on you. We won't have her, but she should be back at the next meeting. Am I started without Commissioner Tweedy? I thought I saw Tweedy here.
He's here. He's here.
Okay. Robin, you can get the vote for him, I guess. No, there it comes. All right. So at this time, we have deferred meetings from January that we make corrections on. Do I hear a motion to approve our January minutes?
So moved.
Okay, we have a motion to approve. Do we have a second?
Mac?
Commissioner Ellison made the motion. Who seconded it? Commissioner Bumgarner seconds the motion. Any discussion on the motion?
Yes, if I
Yes,
could ask
Commissioner
a
Chmielewski.
question. I think you made, the change was added under the PFAS or the 1,4-dioxane?
They both should reflect the intent of the,
Yeah.
continue with this,
Yeah. So
American standards.
I appreciate that. My only concern is that the way it's written, it implies for 1,4-dioxane, commissioners emphasize the need for numeric standards in the future, but agree that monitoring and minimization are critical interim steps. My recollection is that those of us who voted against moving that proposed rule forward for public comment did so because we feel that standards or numeric goals were needed at that time, not so much in the future. So I'm wondering if, I hate to delay this anymore, but if we could put something in that clarifies that it wasn't unanimous.
Okay. We tried to make the right updates. We've got a long tape. Our goal has been to reduce these minutes. And I'll even admit, even though I've took my best efforts, Kevin, I tried to get your timestamps on every heading and they didn't make it this time. Again, my reluctance to set expectations because we miss them, but we have the timestamps. We have the tapes that are the official recording of the meeting. So I'm not going to hold the January meetings any further if we can vote today. I'd like to get them in the books and let the recording be the official tape at this point. We've done our best. I've looked at them. Council's looked at them again. So let's take a vote and see what happens. Any other changes, potential changes to the January meetings? Minutes? Thank you. All right. Hearing none, we have a motion and a second. All in favor, say aye.
Aye.
Any opposed? Okay, same for the March meetings. Do we have a motion on the March meetings? Mr. Smith, did you just raise your hand or were you? Okay. Commissioner
We
Ellison
approve.
again, okay? Second by Commissioner Bumgarner again to approve the March minutes. Any comments or discussion on the March minutes? Okay, hearing none, all in favor say aye.
Aye.
Any opposed? Okay, motion passes. All right, so action items, 2608, number one for today, request approval to proceed to public notice with the periodic review of existing rule reports for 15 AC NC 02C, and that's Mike Rogers. For the commission's sake, both of these first two, I believe, are kind of the bucket list type things, the classification and schedule. They were done before yesterday, so we don't have to do a 30-day waiver, so we can consider this today without a waiver. Mr. Rogers?
Yes, sir. Thank you. My name is Michael Rogers. I am the Underground Injection Control Program Manager for the Division of Water Resources. And what I'm going to discuss with you today is the 2026 periodic review of 15A NCAC 02C. Per General Statute 150B-21.3A, all rules are required to be reviewed every 10 years. An agency placed rules into one of two categories, either unnecessary or necessary. Unnecessary rules are a rule that the agency determines to be obsolete, redundant, or otherwise not needed. And when we do the initial review, if it does not fall into that category, then by default, it goes into the necessary rules. And the Division of Water Resources has determined all of our current rules are necessary. These will go out for public comment for 60 days. And at the end of 60 days, the agency, we will do a report, which will include a response to any comments. And then we'll submit that to the RRC for review. The 2C rules, well construction standards, are divided into three sections: 0.0100, 0.0200, and 0.0300. 100 covers criteria and standards applicable to water supply and certain other types of wells. 0200 includes criteria and standards applicable to injection wells. And 0300 is permitting and inspection of private drinking water wells. This is a example page of our rules that will be going out for public review. As you can see in the determination column, in this sample here, we've determined all of these are necessary. And we have 51 rules in 2C, and have, like I said, determined them to all be necessary. This is our timeline, our proposed timeline. We went to the GWWC last March 11th for permission to proceed to the EMC, which we are here today. And as you can see on our timeline, we project to get the final report to the RRC on November 20th of this year. So at this time, the DWR respectfully requests approval to proceed to public notice for the review of the rules report for 02C.
Questions for Mr. Rogers? Questions for Chair Baumgartner? Any questions? Mr. Baumgartner, Chair Baumgartner, you have a recommendation?
These went through the committee without much of any comment that I remember. So I move to approve to proceed to public notice with the proposed periodic review of rules report for 02C.
Okay, we have a second on that. Second, Commissioner Bailey. Any discussion on the motion? All in favor, please say aye. Any opposed? It's unanimous. Okay.
Thank you. Thank you very much.
Okay. Same thing, request approval for proceed to public notice with the periodic review of existing rules reports for 15A NCAC 02E, and that's Mr. Peel.
Good morning, Chair Solomon and Commission members. My name is again Linwood Peel, and I'm with the Water Planning Section of the Division of Water Resources. And today I'm here to I'm trying to beat Mike's speed. Again, I'm here this morning to bring before you the 2026 proposed periodic review of 15A NCAC 02E, the water use registration and allocation rules, to proceed to a public notice and comment. The agency have placed all these 32 rules into necessary rules, and this is the 10-year review. And the agency will accept public comments for 60 days, and then we'll do a final report of those, including the response to the comments, and then submit to the Rules Review Commission for their review. There's 5 subsections: general provisions, registration of water withdrawal and transfer, registration of surface water transfer, which is IBT, Central Coastal Plain Capacity Use Area rules, and the water use on drought rules, which I mentioned yesterday in the Water Allocation Committee meeting there. This is a snippet of the report, the O2E report that's going to public notice and comment. And there's attachment where you can actually read all the different 32 rules that are necessary. And with that, here's the timeline we have. In March, Harold Brady brought to the Water Allocation for their approval to proceed to the EMC. And today we're here to proceed to, request you to proceed to notice and comment. And then we'll follow with the OAH proposed tomorrow and public comment for the next 60 days. And then we'll work on the package and provide a package for the EMC to adopt in their November meeting and hopefully proceed to the Rules Review Commission for their 10-year review. And with that said, DW are here to request approval to proceed to the public comment and with the proposed periodic rules report of O2E, the water use registration and allocation rules.
Okay. Any questions for Mr. Peel? Water Quality Chair Keen, any comments or?
Water allocation. Water allocation.
Sorry, Commissioner Tweedy. Hearing none, do we have a motion to approve? Commissioner Tweedy?
Move that the commission approve to proceed to the public comment with the proposed periodic review rules report for O2E.
Okay, do we have a second on that? Second. Commissioner Hardison? Any discussion on the motion? All in favor, please say aye.
Aye.
Any opposed? Unanimous, motion passes. Okay, thank you, Mr. Peel. Okay, item number 3, 2610, request approval to proceed to public comment and hearing on proposed revisions to 15 AC NCO 2Q00807, and I'll just call it the Rice combustion rules. And we have, who's doing this today? Mr. Nelson. Good to have you back, Mr. Nelson.
Thank you. Good morning. Here to present, I guess, the amendments that we're proposing for to include non-emergency engines in the exclusionary rule in O2Q 0807. These are generally some acronyms that you may see in the presentation. The exclusionary rules were established to allow some sources of facilities to exempt them from the requirements of Title V, MACT, or NESHAP by defining their potential emissions to be below major source thresholds. Those 100 tons per year of regulated pollutants, 10 tons per year of HAP, or 25 tons for all HAP combined. And this criteria is set out in each individual rule. There's also, we have a set of rules for permit exemptions, which exempts some facilities from having to obtain an operation permit. And that applies to facilities that don't need a Title V permit or has to comply with all the requirements of the 900 rule. We have a rule already in the books for O2Q 0903, which includes emergency generation and stationary reciprocating internal combustion engines. This exemption applies to these at facilities whose only sources are these engines, whether they're emergency or non-emergency, and they have to be below the major source thresholds, but other requirements in O2D will still continue to apply to these engines. At issue is that in 903 we're exempting them from the non-emergency and emergency engines from the permit requirements because they don't meet the Title V requirements, but in O2Q 0807, Only includes emergency engines. So what we're proposing to do is include the non-emergency stationary rice so that we can define their potential emissions using the standards that we've set in there in the 0807. So we're proposing to amend O2Q 0807 to include the provisions for Title V exclusion for non-emergency engines based on actual emissions. We'll redefine their potential emissions as actual emissions. This will allow, what we're asking them to do is to to submit an initial permit applicability determination to demonstrate that they meet the requirements of the rule. And the proposed rule will require annual reporting if the facility-wide emissions are below 75% of the major source thresholds, or quarterly reporting if they're above 75% of those major source thresholds. And this is a rule that we've had another rule like that, for coding and solvents, the similar type rules. So we're using that kind of format to do this. Just to provide you an example, for a facility that has 2 non-emergency diesel-fired stationary rice rated at 500 horsepower, if you use the AP42 emission factors, you come up with 136 tons per year of NOx. So they would be above the major source threshold of 100 tons per year. But if these engines only operate periodically or intermittently, you know, they could still be below, they could be below those major source thresholds. So if we redefine it to allow them to have a limit on the amount of fuel that they could use, you know, the 2 engines would only have 62 tons per year of NOx and therefore be below the major source thresholds and then be exempt from Title V permitting. Some types of facilities that could use this, you know, we look back at some of the permit or some of the operations. We saw there's a construction company using a diesel engine to provide power to a rock crusher. You know, it operates, you know, 8 hours a day. So, or a metal scrap yard that's only operating, you know, during the day. So they're not really operating 8760. And we have another example here of perhaps of a data center here that installs a emergency engine that's certified to meet an emission standard. So we're allowing them to use either their certified emissions for to show that they're below the threshold, or they can use the AP42 standards if the engine is not certified. In this example, this non-emergency engine would have 12.55 tons of NOx per year or CO per year. And they could install up to 7 of these non-emergency engines before reaching 100 tons per year. You know, this type of facility is a true minor source, so it does not need to redefine its potential emissions as actual emissions under 0807 to avoid being a major source unless they wish to install more than 7 non-emergency engines. A new data center that wants to install 500 horsepower engines, fire and diesel fuel, and they're certified to meet that same standard, you could look back at and calculate the amount of fuel that you could combust before exceeding the 100 tons per year thresholds. So this is just an example of using this rule to show that we're going to limit our fuel usage to the 646,000 gallons of diesel per year across all engines at the site, and we'll be below the standard. We did a regulatory impact analysis for the rule. There was a net savings of, 4,000 to 7,000 for newly exempt facilities, not having to require to get a permit. Those are the kind of savings that you would see. There's a net cost of 3,000 to 6,000 for facilities that were previously exempted under rule. They're going to have to reapply under this rule in order to make sure that they are below those standards. And the DAQ costs range from 653 as net savings of $653 to a net cost of $4,000, depending on the complexity of the application and the permit application determination. So we see a total net impact ranging from the rule of savings of 8,000 to a cost of 10,000 per facility. The net present value ranging from a net savings of 8,000 to about 10,000, discounted 7% per facility utilizing the rule. We also calculate the aggregate financial cost. These are costs without savings. For a newly exempt facility, it's if they have to report quarterly, their emissions are at 75 or greater than 75% of the major source thresholds, or about 14,000. And for a newly exempt facility, annually that's 9,000 to 8,000, and that's based on reporting. Since we're not sure, I guess, the exact number of facilities that will be impacted, we kind of back calculated the number of facilities that would have to reach the $1 million threshold. We'd use two approaches. One assumes that all the facilities submit a permit application determinability in the first year, and then the second approach assumes that they all occur over a 5-year period. So what we found is that in using the first approach, at least 24 facilities that were required to do quarterly reporting would have to submit an application during that first year, or 48 if they're having to perform quarterly reporting, or 48 if they're having to do annual reporting. And the second approach, that would be 36 over the 5-year period. Looking back at some of the exemptions that we've received over the years, we've only saw 3 over the past 6 years. So we don't expect that, that we'll reach any of these numbers. This is the timeline. We're here in May seeking requests to proceed to public comment and hearing. Recommendation. And any questions?
I do. Can you go back to your examples?
Sure.
And it's less on the rule, but more on the examples, I guess.
Which one?
You got another one in there, I know.
This one?
That one. Is there one before that? That one.
Okay.
So both of these, and I think these are good slides, are going to be great to send to the public if you do a presentation, let people understand what's going on. The problem I have is you've got a kind of a theoretical one here that says potential emissions from a generic facility. The other one third one and it hits a political hot button, but it hits data centers. So the question is, why are we hitting data centers? I mean, that's going to attract fire. Why is it not a processing facility or somebody else? Because a lot of these places have backup generation, unless that is an actual data center. But you're also saying you don't have but 3 that have ever filed for the exemption. So I like the examples, but I'm trying to ground the examples in reality, especially when you say data center. My brain starts clicking, and I know the public's going to get concerned. So tell me about that.
Well, I mean, the examples, when we presented this to the AQC, that, you know, they were asking for examples.
Yes.
And so, you know, that question came up about, well, what about data centers? You know, we hear a lot about data centers, so we wanted to provide, you know, example, you know, it doesn't have to be a data center. It could be any generic facility, I guess. And maybe that's the best way to put it. Maybe not just say data center, but generic facility.
Yes. Chair Ellison, go ahead.
The committee specifically asked for a data center example because it's a hot button
Yes, I know, I
issue
understand.
in the public. And the division's analysis showed in the example given, a very realistic example, that the data centers are not going to be major sources and that they would qualify under this exemption. And they've got the math to show that the emissions would be below the thresholds. So whether that needs to go to the public as an example, I'll leave to the division, but
Okay.
we requested that because it is an issue.
Right, but you understand my question. I'm
Sure.
saying there's a lot of things that could go in the category that use a similar amount of power and backup generations as data centers. And data
Okay.
centers are relevant. I'm concerned when we go to the public and say, we're giving you an example of a data center. They're gonna say, which data center, or data centers are bad. There's a lot of big facilities that use power. So that's my only comment as we go forward. It's not to
Right.
stop this rule. I think we just need to be careful what we put for public consumption. Yes,
Just to follow up
Commissioner
on
Johnson.
Commissioner Allison's comment, I think we asked for the data center specifically because moving forward in the next 15 years, they're going to be the biggest demand of energy and probably potentially the biggest user of this ruling,
Yeah,
potentially.
I think in the case of data centers, non-emergency engines probably isn't going to be their primary source because you would have to put a lot of them in place.
Correct.
And they would be above the, you know, they're going to run 8760. So these are more,
Correct.
if you think at data centers, they're more of emergency engines. So, you know, they're operated sporadically, hopefully, you know, just 100 ton or 100 hours a year or something. So,
But the energy utilization of data centers cannot be accommodated by the current grid there is. So they may actually be the biggest user of this because the need is there.
right. But it could be that if you're operating an engine 8760 as this example, if you're running this 8760, you know, you're going to hit the major source threshold very quickly. And
Correct. Which is my
so
concern.
These won't really apply to data centers. I don't think if they're planning to use it as a non-emergency engine, in my
Again,
opinion, anyway.
I'm not debating data centers.
Yeah, okay.
We're on the same page with that. I'm just saying, if you look at what's being used today, who is using these? What industries are using them? And because somebody is using these exemptions now, right?
Yeah,
Big power users.
they're small. No, they're actually
Mainly
small.
cogen facilities or what?
Yeah,
what's used?
you know, I gave the rock crusher example, you know, the car crusher, you know, these are just
Yeah.
operating, you know, 4 or 5 hours a day. And
Right. Well, y'all understand the point of my question. And Mike, I think
sure.
Director
Sorry,
represents.
just want to add one more thing. All accurate answers. Mike Ebrzezinskis, Director, Division of Air Quality. On the data center questions, any data center getting significant public interest is going to have far more engines than cited in this example and thus are going to be subject to major source permitting. So this isn't going to apply to those. That's a tiny data center in that example, and no one really is probably most interested in those. And then some of those other examples of who might be impacted by this, keep in mind that this all applies to sources where these engines are the only sources.
Right.
Right. So we're talking about a parking deck. We're talking about a cell tower, maybe unmanned sites that may have an engine or a combination of these engines. So just to give a few additional examples, but I just wanted to clarify on that data center that the ones getting interest, they're
Right.
not going to be able to take advantage of this because they have far more than 7 emergency engines. They're going to have
Exactly.
hundreds. They're going to be a major source.
Exactly, but I think this is a really, really important clarification that needs to be made. So the public is not seeing this as a hot button issue.
Yes, ma'am.
Yeah, if it's not, thank you. That's my only question. I'm sorry I took there. Any other questions or comments on? Yes, Commissioner Smith.
So one question, I don't remember if this came up in committee or not, but I know they have to do the permit applicability determination
Okay.
upfront, and then they do annual reporting. So what happens though if a facility starts with 5, wants to go to 7 or 8? Do they
Okay.
have to do a new permit applicability determination at that
That,
point?
that's correct, yes.
Thanks.
Commissioner Elson.
I would just like to commend the division on taking something that, an issue that many of us found as complex, and doing a real good job of explaining it and laying out the benefits of this rule. It reduces regulatory burden on a lot of the public. So we think they did a good job on this one.
And comments relevant on the Rains Act, and council could correct me. We will officially determine that when it comes back. We'll get comments from the public. They may or may disagree with the RA or any of the estimates or bring new information. So when this comes back to be adopted, if we think it's over the threshold for some reason from the public comments, we will make decisions on the applicability of the Rains Act. But I think it's helpful always to have it going in so we know what to expect and what hills we may have to climb if it does trigger different parts of the Rains Act. So thank you for that. Okay, hearing none, Commissioner Ellison, do you, any questions, Commissioner Ellison or AQC Chair Ellison? Hearing none, Commissioner Ellison, you have a report, recommendation from the committee?
Yes, I move that the commission approve the proposed amendments to 15A NCAC 02Q 0807 and the accompanying regulatory impact analysis to proceed to public comment and hearing.
Okay, we have a motion by Commissioner Ellison. We have a second. Oh, Commissioner Hardison. I thought Jaspers was going to come in. She was in the thick of it. Okay. Commissioner Hardison seconds. Any discussion on the motion? All in favor, please say aye.
Aye.
Any opposed? Unanimous, motion carries. Okay,
Thank you.
thank you very much. All right, so this is the petition for rulemaking pursuant to NCAC General Statutes 150B 20 and NCAC 02I 0500 to revise the 02D 400 to incorporate federal national ambient air quality standards by reference. Now, let me give just a brief preliminary overview about what we're about to do, because we don't always do it very often, and most of you commissioners have not been through this process before. Start off with the broad definition. And you can go to the OAH site. It used to have all the sources for rulemaking. One could be we as the rulemaking body could ask the department as our supporting staff to bring us rules. The department as the implementation and enforcement agency may bring us rule revisions too. That's normally a very public body driven process. The General Assembly can tell us to do certain rules. The courts can tell us to do certain things to the rules. And nationally, every state has it, federal government has it. There's always a petition for ordinary citizens, groups, citizens, whatever, to bring rule petitions to the rulemaking body. So that is in our Administrative Procedure Act in North Carolina. And then we have our 02I rules that also put another layer for this commission on how we may look at petitions for rulemaking. So the process is multifold. The first part speaks about the application that the applicant has to make, the petitioner has to make. That's reviewed by the department, and there's a criteria for that. And if the department finds it's acceptable, then the department sends it to the chair of the EMC, and I look at it and decide what to do with it. And there's a couple paths that we can go down, which bring us to this. Now, in those rules, what will happen is normally when with rules and the statutes, the department typically can weigh in on these decisions. So they usually do the first presentation about what this is and the rules and all those kind of things. Next, we go to the applicants that usually give a presentation. It's not specified, but usually we limit that to about 15 minutes. And we ask the applicants to understand we may have questions, so please keep the total deal to 15 minutes so that we can tell you to stop after 15 and hopefully all our questions are answered if possible. We don't have a required time limit. That's just the ground rules we established kind of informally. So we can play with that a little bit, but I do want the applicants 15 minutes each. It also allows for the chair of the committee or the commission to pick a party that expresses interest to speak in dissent of or against the motion of the applicant. And in this case, we had an individual citizen come forward to speak against it. Sometimes we've had 3 or 4 entities want to do it, and we've had to pick them. But in this case, we had one, and so as the chair, that party will speak second in the process. And then when all the parties have decided what to do, then we'll decide whether we accept the petition for rulemaking. The actual rulemaking begins when the chair of the commission accepts that decision of the commission to proceed to rulemaking, and then I assign it to a committee as the chair. So that'll be the official rulemaking process. But right now, we're weighing in on petition. So any questions on what we're about to do? Okay. Council, can you add any elaboration to that or? No, do you have something that I missed or? Okay, so this time, Director Abrazinskis, this is air quality, so we'll let you do your brief presentation on what specifically this is about.
All right, thank you, Mr. Chairman. Good morning, everyone. This is a bit of an unusual situation where the division received a petition for rulemaking that seeks an outcome that the division is already working on as part of the rule readoption process. So in short, petitioner seeks to adopt the National Ambient Air Quality Standards, or NAAQS, by reference. That's something the division is working on in the first group of rules we're bringing to the commission for readoption. And while the division may use some different words and structure to the regulatory text than the petitioner, the outcome being sought is the same. The division's motivation is simple. Adoption by reference of these standards saves staff and the commission time and resources. And in fact, the effective date of the National Ambient Air Quality Standards, or NAAQS, when they are changed by US EPA, is usually 60 days after publication by EPA. So going through the lengthy state rulemaking process every time the NAAQS change has been somewhat of a mere formality, as the division was already implementing the new standard as of that federal effective date. So my only slide today compares the timelines for accomplishing the outcome that both the division and the petitioner are seeking. And as you can see, if the commission grants the petition that's before you here today, the rulemaking process would commence, as the chair indicated, and that would likely result in the same final effective date as the division's planned pathway for the same set of rules through the readoption process. That's all I have, Mr. Chairman.
Okay, thank you.
Thank you.
Director Abrazinskis, very much. We will now hear, and I'll ask council to keep the clock on this, but from our petitioner, Mr. Charlie Carter, representing, I think your entity now is Earth and Water Law, right? Commissioner Carter or Mr. Carter?
Yes, sir, that's correct.
Are you ready to take the podium? Okay, very good.
I would like to make one request.
Wait a minute, let's get you to the mic so I can.
Thank you, Mr. Chair. I'm glad you let that slide up. I would like to make one request, which is since we do have an objector who's going to speak after I do, I would like to reserve 5 minutes at the end to respond to anything that comes up in that process.
Yes, sir.
I do agree with much of what Director Abrazinska just said there. The process that I'm proposing is similar. However, I don't necessarily agree with his timeline here. That seems awfully stretched out for a very, very simple petition here. All I'm suggesting is some slight work changes and eliminate the provisions of 402 through 410. To September, it takes to September to get it into the register. I don't see why that should occur. It should be, if it's done expeditiously, it could be in July. Certainly should be in by August. And for some reason, this schedule jumps over the January meeting, which I don't understand either. This is a rulemaking that should be completable by the end of the year or at the latest by January. Now, the major difference between what I'm proposing and what the DAQ is working on is as follows. I see I think his schedule is a bit, it's ambitious, but I'm not sure it'll be followed. What my experience when we did this, the readoption process back in, I think it was 2018, the readoption process does not move that quickly. It always ends up dragging out. And for example, I know he's got a stakeholder meeting coming up later this month, the 21st. Who knows what's going to come up there, more issues and so on. So I'm at least skeptical that he's going to be able to proceed as quickly as he's suggesting here and start that process in July. My point is we need to get this done quickly. And the main reason is because of the new PM 2.5 standard that's the commission adopted into the rules January a year ago. It's unfortunate we didn't wait to see what EPA was going to do because by March, before our March meeting, EPA announced that it was going to reconsider that standard. It had already asked the DC Circuit to hold the litigation over the standard in abeyance. And that has continued and still continues to today. And most recently, well, excuse me, let me take a step back. The new standard was promulgated by the Biden administration, excuse me, published in the Federal Register on March 6, 2024. Also on March 26, 2024, 24 states filed a petition for review objecting to that standard with the DC Circuit. And that's been the major litigation that's been ongoing since then. That's the litigation that's now in abeyance. Most recently, EPA has filed a motion to vacate the standard entirely. And basically what they've said is, look, this standard was not set properly. It ignored the statutory regulatory process that's ordinarily followed. It jumped through some hoops that don't exist for doing this. And the standard is, in the agency's view, erroneous and needs scientifically improper and erroneous and needs to be vacated now. Now, the DC Circuit has that motion pending at this point. They've not acted on it yet, but they could act on it tomorrow. They could act on it next week. And the point is that when that happens, the standard is going to go off the books for federal matter, but it still would be in the state rules. And I think that's something we need to avoid, or at least limit as much as possible. There's one piece of background in this I'll also point out is this is a practice that is the adoption of individual standards that's going on for nearly 50 years now, I guess. And frankly, I don't know how it started or why it started, but it's totally unnecessary under the statute. There's nothing in the statute or regulations that require states to adopt the standards into their own rules. And so the incorporation by reference is simply the way of just correcting that and simplifying the rules. It's also something we've done, you find throughout both the air rules, the water rules, the record rules. Adoption by reference to federal standards is It's a very consistent process throughout. So I don't think there's any disagreement there at all. As I say, I think that the main issue here is to move this and move it quickly so that the state rules will be consistent with the federal rules once the withdrawal of this standard takes place. I don't know that I have a whole lot more to say. As I said, it's a very simple matter. Oh, I'm sorry. Yes, I do. And as far as the other part of the process, one of the things that I think will also more likely to delay the readoption process is the accompanying fiscal note and so on that has to go along with a rulemaking. I don't know what that's going to look like for the readoption process, but that process includes several sets of rules. This rulemaking involves this simple rule, and the bottom line is there is essentially a zero fiscal cost, zero impact. So that's why, in my view, this can happen very quickly, should happen very quickly, and can be done. As I say, I don't see any reason it couldn't be done by the end of the year, at the latest. Beyond that, I really don't have anything more to say. If anybody has any questions, I'll be happy to answer them.
Mr. Carter, you're at about 6.5 minutes, 5.5 minutes. So, so the question I got for you is basically what you're saying is instead of adopting these standards and the rules every time, we just adopt it whenever it changes at the federal level, it'll change here automatically when we adopt it by reference. And
Correct. And Director Abazinski has pointed that out. I mean, he's exactly right. He's going to save them time and effort, save the commission unnecessary rulemaking. It's really, it's a win-win situation all the way around.
Is the double benefit here, we kind of got out front on the 2.5. That may stand up, it may not, but
well, yeah.
Is the double benefit if they drop the 2.5 or those provisions of the 2.5 that we won't have it on the state books?
Yeah,
that's federal, but
I'm sorry, that's correct. Yeah, I think we did get out ahead a little bit, and I will take some responsibility for that. I should have advised you in January 2025 that we should hold off and see what EPA was going to do, because it was clear that they were going to review and reconsider a number of actions that had taken place in the previous administration. We had already halted the Clean Power Plan 2.0 in the Air Quality Committee meeting the day before. And as it happened, we had been involved in a rulemaking on the 2.5 standard, and it just happened that the hearing officer's report had come back for that January meeting. If we'd waited till March, we would have known that EPA was going to take a look at this, and then it would have been a decision to make, but I think it would have probably been correct with you to wait and see what was going to happen with that. So.
Additional questions for Mr. Carter. I'm sorry, guys, it's an old habit. Commissioner Smith.
So I don't think there's a lot of controversy about the concept of adopting by reference. As you say, there are many other federal standards that we've adopted by reference. But the question I have about this petition is I don't see language in the petition that actually does that. I mean, when we adopt by reference, we reference the specific federal rule and include a citation to the federal rules that we are adopting by reference. And I just don't see that in this petition.
Well, it doesn't include specific individual rules because of the fact if we do that, then you're still going to have to modify that every time a rule changed. That's why the reference in there is to 40 CFR Part 50, where all of the rules are included.
Is there a reference to 40 CFR Part 50?
I believe so.
And adopting it by reference with changes?
I don't have the petition up here. I'll take a look at it, and I can answer. I want to get back up, but I'm pretty sure I included it in there.
It's in there.
It's in there.
So my question is, what's in there is a statement of purpose. It says the purpose is to adopt by reference the National Ambient Air Quality Standards in 40 CFR Part 50, including subsequent amendments and additions. Is that sufficient to be an adoption by reference? That is stating the purpose of the rule.
Yeah, I understand.
It then repeals the specific standards that we currently have in the rule, but there is nothing that actually adopts by reference with changes the rules that are in that section.
I think it probably does, but let me go back and take a quick look at. I don't have the other rules here, though. I don't think. My recollection is that when I drafted that, I thought I pulled that language straight out of 401, and simply included the 40, 40 CFR Part 50 reference, but let me take a look. It may be that there's an adjustment needed in the language, but I think that can be very easily and simply done if, assuming that a rulemaking was initiated.
Commissioner Ellison.
I was about to comment.
You were gonna
on-
give a
on
clarifying
what he
comment
just
on that.
said. That would be a very simple fix. If the commission decides to move forward, that could be fixed in committee and working with the department.
Which raises the question, Mr. Chairman, that came up yesterday, which is my understanding of our options on a rulemaking petition are that we either grant it or deny it. And the text that's proposed in the rulemaking petition is the petition. So we grant or deny. If we grant it, then we have to initiate rulemaking, and the statute that describes this process clearly ties initiation of rulemaking to publishing notice in the state register. I have struggled to find anything in the state law, in the APA, that allows the commission to change the language of text proposed in a petition after we have granted the petition.
Let me-
So I think
let
we
me try
need
to
some
answer.
clarity on
Yeah,
that.
let me try to answer, unless, can we stop his clock? Because, I mean, I think this is kind of like discussion of the motion, but let's go to the clock. I'm gonna give you a couple pieces of information. I thought we might go to this at some point, and I guess we are now. You all have had this from your orientation information that you came on, and again, I acknowledge many of you guys have not been through this before. Some of these don't have staples on them. I may have to look at yours, Joe, because I think I just handed mine out. I've given you three pieces of information. Let me see the first one first. As you get those, 150B20, which has been identified up front as governing APA citation, talks about petitioning an agency to adopt a rule. And so what you'll see on that first page is what really has to happen in the petition in the APA, which is under A. I'll like to give you time just to scan A. And B, it talks about our time that we have to, it's 150B-20, it's a one pager, A, B, C, D, E. And then action that appears under C, which is if an agency denies a rulemaking petition, it must send the person something in writing. The next two sentences are probably the most relevant. When an agency grants a rulemaking petition, the notice of text it publishes in the North Carolina Register may state that the agency is initiating rulemaking as a result of rulemaking petition and state the name of the person who's submitted that. So we don't want to know what the source of that is in the petition. And the text is may. If the rulemaking petition.
I'm sorry, can you point out where it says may? I'm not seeing it.
It's in the middle, C, it starts when, the second sentence, it starts when. When an agency grants a
Yep,
rulemaking, the
found
may
it.
state.
Yep.
And then you go to the next sentence, if the rulemaking petition requested the creation of amendments of a rule, the notice of text the agency publishes, again, I'm gonna talk about that in a minute, but the burden of publishing in the register is on the agency, which is us, not on the petitioner, may set out the text of the requested rule change submitted by the rulemaking petition and state whether the agency endorses the proposed text. So we have the ability as an option here to adopt this. If we don't like it, we can publish that in the register and then say, we can make the minor, as Commissioner Ellis said, we can make the minor adjustments or adjustments to that as long as we state in the APA, that is what we're doing in the register. That's in the APA under C. Now, if you look at 150B 21.2, which is the staple, there's two pages of that one I gave you. And it's referenced as A, it's the steps. And then it says before an agency. And this goes to once we adopt this petition or any petition for rulemaking, we go through rulemaking, we must put the notice of text to the register and we must do the regulatory impact analysis. Right? And then if you read down under C, it'll say the notice of text, and it's a lot of the stuff we require the applicant to put in there, like the text, why we're doing this rule, how does it apply, blah, blah, blah. So they're doing some of the legwork, but the point of 150B 21.3 is that this agency, as we go through our rulemaking, before we publish it for public comment, has to do that legwork. And then as 150B 20 says on this one, we can put if we agree with the petitioner's text or not. Let me stop there because that's APA, that's law. We'll get to our rule in a second. Generally speaking, and then I've talked to a lot of attorneys, some attorneys in some other states, and when we do these things, we are required to be the experts, right? And the agency that includes the department is required to be the experts. That's why on some of the stormwater stuff, we experienced such frustration yesterday, is it didn't look like we knew how to align the rules with the statutes and all the things that go on between the RRC and this agency and other bodies to get the exact language right. But generally speaking, and you'll see that, I think Mike, Director Abrazinskis has approved this as meeting sufficiency for the petition. And I've looked at it and I've said, yes, it meets the minimum sufficiency outlined in the statutes. So it has cleared that hurdle. So it meets the minimum standards. Now it's up to us to decide how we put it in the register if we approve it today. If we disapprove it, we got to tell the applicant why. And if that is not consistent with the law, clearly he has an easy path to OAH and the Superior Court to appeal whatever we decide. So ours must be bounded somewhere in the statutes, or this will go straight to OAH and they'll say the rules don't match up with the statutes and y'all go back and work on your rules or reconsider this.
Can I ask a question, Mr. Chairman?
Yeah,
So-
let me finish my thought though. Let me finish my thought. So when you see this done at different levels, the applicants don't always get it right because they're not experts, perfectly right. And that's why the provisions are in here. And you see these in under state and federal, that the rulemaking agency, before they publish it, can publish their exact text and put comments on it to say, we don't exactly agree with that. And we probably are going to change it to this. As long as the public's informed before it goes to public comment, that's allowed. I'm gonna go to rule, but go ahead.
Just want to make sure I understand exactly where you're coming out on this. 'Cause I can't tell if we agree or not. But, so I would agree that the commission could grant this rulemaking petition. I think the law requires us, however, I believe, to send it to public notice in the form it appears in the petition. I don't think the law allows us to change the text of what is proposed in the petition before it goes to notice. Now, we can send it to notice with exactly what's in the petition and include the statement. Those may statements in Part C are not making publication of the notice of text optional. It's allowing the commission to attach additional statements to that notice to make it clear that it's been initiated by rulemaking petition and to make it clear that the commission itself may or may not endorse the actual text of that rule, of the proposed rule. So I agree we could do that. I just want to be clear that everybody understands what I think the law makes clear, which is that our only decision at this point is to grant or deny the petition as it was submitted. And if we grant it, the text as proposed by the petitioner would go to public notice as it's currently written. And we can put a statement in the public notice saying we don't necessarily endorse the text. And then when it comes back from public hearing, obviously the commission doesn't have an obligation to adopt it as it is proposed now. The commission can do what it does. So if we're on the same page about that, I think we're good. I think there was some confusion yesterday about whether after granting a petition, the committee, in this case, the Air Quality Committee, could make a change in the text before it goes to notice. And I do not believe the law allows that. And in fact, if you look at paragraph A, one of the things that it says the petition must include proposed text. And then it says the agency must send that proposed text to the Office of Administrative Hearings within 3 days after the petition is received. And that's before the public notice on, if it's granted.
Right. I think we just disagree on one point. The debate about exact language is not in the statutes. It doesn't say the petitioner's language has to go into the NC register. If you look at 150B2, what the agency has to prepare, it doesn't say explicitly that. And let me give you the reason I say that. It's not explicitly that it has to be exact. Most of these laws don't anticipate that the petitioners are going to get it exactly right. And truthfully, most of these we've seen in the past are very dense. They're more than just one line almost is what this one is. It is a series of things. And when they've been thrown out, it's because somebody says, you need to do this. Well, it's connected to 5 other rules or statutes that would have to be fixed. And it's a blob of things. And so there is a good reason to say we need to consider when the petitioner brings it in, the exact text, so we can get an understanding of what they mean. And we can come back and say, these are tied to a web of other things, and this is invalid. In this particular case, it is as simple as you'll ever see one get, and as plain, and the understanding is plain enough that our committees and the RRA adoption know exactly what to do. And so on those grounds, you have a hard time saying if the exact language is right, we're not going to do it. I think if you grant it, we have to send it to a committee and figure out. And I do think if you think this has merit and we grant it, then we have another step is the when we get it ready for register, which means we got to go through the rulemaking process to do that. I will agree it would probably be safest to put the exact language in there and do exactly what this says and say we want to change that overarching verbiage, but it does not. That doesn't change the meaning of the rule, I don't think, in this case.
Can I
It's
just
y'all's
add
decision, yes.
add just one quick thing, which is, I think the totality of the statute, if you read all the sections together, to me makes it very clear that the text of the rule as it's proposed in the petition is what should go to notice. But I'll also say, and this is a relatively simple one, but we're probably going to see this issue again, which is the part that's a little bit scary. Because I think if we start changing the language of text that's submitted in a rulemaking petition after having granted the petition, we're actually putting the petitioner's rights at risk because the petitioner is entitled to appeal if we deny the petition. If we grant the petition, but then change the text in ways the petitioner has never signed off on,
Right.
we have a real legal issue there with respect to the petitioner's rights, what the EMC's decision was, which is why I think it should be much cleaner. And again, if the commission wants to send this petition with this text out to public notice with a note that the commission doesn't endorse the specific text, that's clearly allowed. But I think it is a very dangerous road to go down to start saying that we can change the language of text in a rulemaking petition after we've granted the petition and before it goes to public notice.
Yeah,
I'm done.
and I do see both sides of that. I do see both sides, and I don't disagree with you. I just think in this case, we have to, I'm going to be more pragmatic about it and say we have to consider the context and look at some of these things where the flexibility is provided. On a simple rule, we don't need to be boxed in by what we might do on a complicated rule. Because if we do start changing major language on a complicated rule that's presented to us, we got a problem. If this, in a bigger rule, this would probably be editorial changes, in my opinion. Now, that's the opinion of this commission. Y'all have to vote. It's not JD's opinion here, the chairman's position. It's y'all's position of how big this is. But I can tell you, if you got a 30-page rule petition and this piece changed a little bit, you'd probably say, that's just a minor thing. But I do agree that we don't want to start changing things that change the intent of the applicant. So I think the spirit is well understood. It was understood by the department when they granted this. Department has said, director has said, this is basically what we're going to do anyway. So there's no mistake about that. And we have an option here in this case with a simple rule. That is y'all's decision. But I don't think you're doing anything wrong by adopting this and then figuring out later how exactly we want to word it and how strictly do we want to follow the may here. So Commissioner Bailey.
Thank you. I agree with the interpretation of Commissioner Smith. It's clear that it's just setting the policy. It's not actually amending or adopting the federal standards. And if you look at the rest of the regulations, they use the word, this standard shall be this and that. So you normally see the word shall when you're doing something like this. So I think the drafting wasn't correct, and everybody seems to agree on that. So what I wondered about is if we were to make a motion, hypothetically, would someone be making a motion to approve the petition, but then I'd want to see some wording about the text we're talking about, whether the agency endorses the proposed text. What would that actually say?
It is a little akin to what was said earlier about up or down. I think you either accept the petition and go forward with it in the rulemaking where we may or may not make adjustments to it. Or you say we deny it and you tell the applicant, if I'm hearing the kind of your thought, is you didn't get the exact language right, so we send it back to you.
Well, it
And-
says that we can do that. It says, and whether the agency endorses the proposed text, because that's what I'd want to have. And if we were to agree on this, I'd want it to
What?
include that
Yes.
under 120C, paragraph C, last sentence.
Okay, let me go to council on this one.
Let me clarify the process. If you were to grant the petition today, that is the only decision you're making today, is grant or deny the petition. If it is granted, then the decision is to initiate rulemaking on this petition. Per your bylaws, that means it goes back to the committee to begin the rulemaking process. If it gets through, when it gets through committee and commission to go into the register, that's where it's during that process that you can decide when it goes into the register, we want to add some additional context to say, we agree with the intent, we disagree with the way it's presented, we plan on changing the language if that's the will of the commission. But today, the only decision is, are we initiating rulemaking based on this petition? Are we granting this petition or are we denying this petition?
Thank you. That clears it up.
And I just want to say, again, I'm not advocating either way. I know I have my own way of reading this thing. Some of you will say we never want to do a petition, one of these petitions before. And the way to do it is say, we're going to live by the exact, never change a word, and then most of them will fail. If you have a lower bar, if you have a high bar, that'll happen. If you have a low bar, you'll take some of this and use this may provision. I think that's the span of what we're talking about. And it is up to individual commissioners how they see this. Look at it on the merits of what you've got and do what council said. Any other, Commissioner Chmielewski? Yes, I know some of y'all going through this for the first time, so. Yep, and then I'll go to Yarborough.
I guess just a comment or maybe question. I'm struggling to understand why we would grant a petition for a rule that would affect the same change on a petition about which we have concerns about the language that have been expressed when the division is pursuing the same rulemaking on the same timeline, other than that the petitioner says it might happen a bit faster. So I'm just kind of at a loss about what the advantage would be.
Yeah, that is your decision. But what we have to do is look, and you see the timelines respected, that we have to give responses and act on the process here. We have to consider this petition on its merits. It did not require the applicant, because the applicants do not know what the schedule will be. That schedule was given you by DAQ, and the applicant said that this should be done in a year, because there is not much to the fiscal now for this simple one. So I'm not so sure the applicant's bought into the schedule. In fact, he said he didn't. But that is your decision to make. But please make it on the scale of the merits of what we're doing today, not what we might do in the future or what the department's proposal may look like. You've not seen those rules from the department yet. You've not seen some other things that may change here. So we need to consider on the merits that's been presented to us today. Commissioner, yes.
Okay.
Counselor.
I do want to clarify that on the back end of all of this, after it goes out, if you were to grant the petitions, put the notice of text as it was presented out to public notice. On the back end, you can make changes to the language of the rule as long as those are not substantial changes. So there is a way to modify the language after it goes out to public comment. So in this particular instance, currently the language reads, the purpose of the rule is to incorporate the NAAQS by reference. You send that out to public comment, say we're not endorsing the text, we're going to clean it up for APA purposes. When it comes back for the idea of whether to adopt or not, you can modify the text in a way that isn't a substantial change to the rule by simply saying something like the provisions of 40 CFR Part 50 are hereby incorporated by reference, including any subsequent amendments and additions. So you can clean it up on the back end. That is possible.
Okay, Commissioner Yarborough, yes, sir.
It appears to me that sometimes we get ourselves into positions of grandeur. If in this situation, we have a former commissioner that is an attorney, that worked as the chair of the committee, asking the request as a general purpose for a petition for something that he thinks he failed in, or that the group failed in when they did what they did. Now, that's saying a whole lot in one respect. But on the other side of it, if I was a common man and wanted to make a petition to this group and by God don't have no money to hire an attorney and worry about all the stuff that we'd spend hours on, I couldn't come in here and say anything. So I think basically, if we can't approve this one with the background that this man has, then I don't see how we'll ever bring them. I would make a motion on that to say we don't do nothing if anybody wants to come up here and talk. So that's enough. I would make a motion that we accept this petition.
We're not quite there yet. We got some more hearings to do, but I understand. Commissioner Tweedy.
I think we need to hear from the opposition. I mean,
We are. I was trying to answer the questions on the
We're
language.
doing a lot of deliberating
Yes.
before we give them their chance.
Yeah, I said that's why I stopped the clock. So if we don't have any more questions on this topic, let me bring the petitioner back up, because petitioner, you only have 5 minutes and 50 seconds expired, and we may have other questions for you. So if I can bring you back up, Mr. Carter, in case we have other direct questions for you before I turn it over to the, does anybody have additional questions for Mr. Carter? Okay, Dr. J. And Mr. Carter's back at the mic for the recording.
So thank you for what you presented. I guess what I am not clear on, given that the department is already doing this and you think it can be done quicker, I'm trying to understand what you see as the urgency. What will benefit if by granting your petition versus the fact that the department's already got this underway?
But as I explained earlier, I think it needs to be gotten out of the rules as soon as possible, because I think there is a potential for some issues in the future if we don't. And as I said before, I do not subscribe to that group one and readoption schedule. I don't think they'll come close to that. And
Yeah,
I think
but you're
the
not getting at my question.
I think I just did. I said, I think it needs to be off sooner than later, because I think there
And
are
why?
issues. I think there could be significant regulatory issues if that rule is on the books. when
Can
it's
you
off the
elaborate
federal
more
books.
on that?
Well, it would be an enforceable state rule if it's on the books, and the federal system is operating under a very different standard. And
So
that's why
what's
I
currently
think,
being impacted and what relief would be gained if this were to move more quickly?
well, it's not current impact, ma'am. The rulemaking issue is for future. It's looking forward that there's going to be issues, I think potential regulatory
speculative.
complexity. To a certain extent, but except I think there's been some of that already, frankly, with one of the rules that's still in place, the TSP rule, I think has caused some issues over the years that have not ever been completely laid out for this commission. And I don't want to, I just view that as an example. I don't want to see the state go through that again. Mr. Chairman, I want to review that, reserve the rest of my time so I can respond to the.
Yes, sir, that's fine. If we have no other questions, Commissioner Chmielewski, do you have one for the applicant?
Yes.
Charlie, Mr. Carter, can you come? We got to take questions right now, and then you still have time.
Mr. Chairman, I can answer questions at the end when I get back up. That's why I want to reserve the time and not.
Let's take one more question here.
Kind of a follow-up to Dr. Commissioner Orm Zavaletta's question. In terms of the urgency, you state in your petition, the current issue is the revised PM 2.5 annual standard of 9 parts per million. And your concern that because the EPA is considering changing that standard back to the previous standard of 12, and you state what the agency has stated about the new standard. And you say that that will result probably in reinstatement of the prior 12 parts per million standard. So I wonder if that is the urgency you're
Yes, so that we would move back to the 12 as soon as EPA withdraws or either withdraws or vacates that standard.
Can you, and the urgency for that?
I've just answered. There's nothing, I don't have anything more to say. I've seen issues in the past where standards have stayed on the books in the state unnecessarily after the federal standards have been revoked. We've got two standards in those rules right now. One was revoked by EPA in 1984. Well, that's not a standard anymore. At least it says repealed. We got a standard on that was revoked 40 years ago, and yet it's still on the books. Why? Yeah, and there have been issues related to that standard, and the rationale for it that we heard many years ago from DAQ for retaining it was nonsense, frankly.
Okay, let me cut that off and let's mark his time. We got his time. Okay, and you do have reserved time, Mr. Carter, as the applicant to respond. I'll now call on Ms. Carrie Pickett as a citizen to speak in opposition to the petition.
Hi, so my name's Carrie Anna Pickett, and I just happen to have a little bit of background in this area, and this happened to go across my feed, and I was interested in the upcoming rulemaking. There's actually going to be on May 21st next week, a group one, which these 400 rules are in, a stakeholder comment meeting. So if you did pass the petition today, I don't think I guess that's not going to matter for at least the 400 rules. So anyway, that's how this kind of came up and caught my attention. I'm here today, not necessarily against the idea behind the petition. Obviously, easing the burden to the state agencies is something that I think is important and a valuable thing to consider. But I'm here to kind of give a opposite viewpoint as far as things that this body should consider. One of the things that I wanted to bring up have actually already been brought up by y'all, which is the wording for it. I think our state agency and personnel are excellent at getting in and making sure that they have a legally defensible way of rewriting or amending the rules. And since the process wouldn't really change the effective date, why not let the readoption process, run its course? So you guys have already discussed that heavily, so I'm not going to get into that too much. The other reason is these rules are 50 years old, right? The 400 rules were introduced in 1976. I happen to be a little bit of a nerd and have done a lot of research on why we even have the rules, how do they come about? Well, it's to give a cushion. It's to give flexibility for our industries and our communities in North Carolina. It's actually to be protective, to have these rules individually written out for each standard. And actually, the exact example the petitioner is giving us, which is the 2.5 standard, and when there's legal uncertainty going back and forth at the federal level, y'all as an EMC commission can actually be protective of our state so that businesses don't have to wildly swing one way or the other, so that no matter what the federal government's doing, we can be a steady hand, science-based, balancing the needs of our industries, our communities in North Carolina. And the commissioner, excuse me, sorry, I'm used to,
Mr. Carter.
Yeah, Mr. Carter. Sorry, I kept wanting to call him Commissioner Carter. He brought up a good case. And so this is actually a ruling that was done in 2024, and it's the case of Ohio versus the EPA. And there was a 5-4 decision. It was a stay, and it had to do with this criteria pollutant. Actually, it was ozone in that case. And specifically with it, we don't actually know the outcome because the DOJ dropped it. But what we did know was an idea of where the court is thinking and where it's planning on going. And as far as our 400 rules are what our permitting rules are based on, and then our permits and how we accomplished, cleaning our air and meeting our standards is how we have a state implementation plan. If for whatever we don't follow the state implementation plan, the federal government, their EPA can put in a FIP. So that case was all about FIP action, which is where the EPA comes in and say, we don't like what you're doing. We're going to make you do this, right? 23 states sued. There's a whole back and forth about the stay of it. But the point of that background is the court put in a stay, but it was because they think the final outcome of the decision would be that, hey, EPA, we believe that the Clean Air Act has a big state interest. And so if we want to keep a state-based control over our rules and to be enforcing our environmental protections, let's keep it at the state level. You know, whatever the federal government's doing, we can still have our rules as a backstop. And you could reward them different ways, of course. I have like 7 or 9 different ideas of how you could reword this to accomplish both what the agency is wanting and what the petitioner is wanting. And so that, you know, it's kind of a win-win without this kind of rushed approach. So that's where I'll leave it for right now. Sorry, I've been sick for a week, and so I wish I had some water, but because I've been taking like medication now. But anyway, I promise I'm not going to get anyone sick. But yeah, that's where I'll leave it for right now.
Okay, thank you, Ms. Pickett. That's very good. Mr. Carter, you've reserved some time? How many minutes does he have?
5 more minutes.
About 5 more minutes for any refutal or any other discussion. And Ms. Pickett, you're short too. If you got something else to say,
Well, I don't think I'll need 5 minutes. I appreciate her interest and her research, but I think her points are not really well taken, because the point of the SIP process is it's based on the federal standards. And so having the federal standards written into the state rules doesn't change that in any way. If anything, it may complicate things for the reasons I've already described. So I don't think there's an issue there. And while rule changes, I will agree with Commissioner Smith. This perhaps is not the best wording. I'm going to take a look at it again myself and think about it a bit. I'll just say that the wording, what I was trying to do was make this as simple as possible in terms of the wording change. So I simply took the 401 language, and instead of the to establish blah, 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 and inserted the adopt by reference language for 40 CFR Part 50. I did not concede, go back and take a look at any of the other adoption by reference rules that are in either the air rules or any of the other to see if that was done exactly the same way. I think it probably works, but I think you've got a useful point about it. Maybe it might need some, at most, editorial change, and I'd certainly be willing to accommodate that if, and certainly that's what the Air Quality Committee would be doing. If this petition is approved and the rulemaking goes forward, I think that could certainly easily be done at that time.
Okay, very good. Ms. Pickett, I'll let you, if you had any other one final brief statement. I don't think you had much.
I'm just going to read one of my final closing statements.
Okay.
Sorry about that. Okay. So, with all that being said, by following the periodic process that's already in place, this is going to allow for more reflection on the part of the agency and stakeholders on how best to balance the burdens of the National Ambient Air Quality Standards, the rulemaking, and while protecting the independence, flexibility, and transparency afforded by the current 400 rules by breaking it down individually for each rule. You could do an incorporation by reference for each rule. You don't have to do it for a whole big group of them. And there's really no urgent need for this right now. And like the director mentioned, that right now, the way that permitting is currently handled, these are automatically being enforced from a compliance standpoint, you know, automatically, even before they're adopted officially into the rules. So that's already happening because so far our state hasn't contested whatever the standard has been from the EPA. But by having our rules, if North Carolina ever wanted to, you can. So that's what I'm saying is you're kind of giving up some future flexibility and cushion that again can benefit our industries and our communities by having that control. I worry about the commission giving up its control. I would prefer to keep this with the state. I'm a big believer in states' rights, state independence, and that's kind of what was emphasized in the Ohio versus EPA decision was state independence. And what's more independent than us having our own specific rules? So no matter what's happening at the federal level, we can create an environment that's consistent for our industry and our communities. So with that, I'll close. Thank you.
Thank you, Ms. Pickett. And for the record, just note that we've concluded with the petitioner and the party that's in opposition. Both were within their timeframes, and I think both did a good job of their positions. So with that said, questions or I've cut off a motion down here, but do I have a question for you, Air Director
Just a
Ellison?
comment. There's been much banter about process and what exactly how we could or should adopt or proceed with this petition if the commission chooses to do so. I think we've got some of the best legal minds on the planet sitting around the horseshoe, and we can resolve those minutia. And I'd rather we focus on the merits of the petition, the merits of the other side, and focus on that rather than exactly how we have to do it. Let's decide if we want to do it.
Let me stay focused on questions for a minute. So we can save some of the comments for after motions, but do we have any more questions? Commissioner Smith?
Can I address the
questions?
question to Mr. Abrazinskis, sort of a technical program question about how this works in
Yes, I think at this point,
implementation?
before we make a motion, we can hear from Director Abrazinskis or Executive Director Evans, if the council so has a question.
This sort of goes to the question of urgency and how new federal NACs are implemented. So we're talking about national ambient air quality standards, not individual emission limits. And as I understand it, the NACs, when EPA changes one, that triggers a need for the state to change its implementation plan so that the state as a whole doesn't violate the national standard. But it does not have an immediate impact on an individual permit holder. Is that correct?
Well, I mentioned, great question. Thank you for the question. And as part of my remarks, I mentioned that for most of the NACs, they take effect nationally 60 days after publication. And so that's on that track, that's the date by which we start in our permitting process, holding applicants accountable to that new national standard, regardless of whether we've adopted it at the state level yet or not. On this parallel track over here, you're right, there's this whole set of requirements in the Clean Air Act for the state, because this is a national ambient air quality standard, and there are timelines that the state must meet, and we're in the middle of meeting those timelines for the aforementioned 2024 annual PM 2.5 standard. In fact, we have a deadline of next February that still remains because the DC Circuit has not acted on EPA's request to vacate that standard. So getting back to the urgency, I noted some of the discussion earlier because, you know, if we live in this hypothetical of, well, if the DC Circuit acts in a way and that EPA has requested, and that is to vacate that annual standard for PM 2.5, and then that mandate is issued, then we will no longer be implementing that standard in the United States, regardless of what our state rule says. We will no longer be holding permit applicants accountable to that standard if the mandate issues and that standard is vacated, regardless of what the state rule says. So I think that's, and then obviously we would also halt all the other state level activities that are required under the Clean Air Act to implement that standard. So there's kind of the two tracks there for implementing the NACs.
Thank you.
Additional, well, hold it to questions. I got to go with the process here. Additional questions for staff here?
Yeah, just a, oh, sorry, go ahead.
Mr. Bailey. Question.
Well, this just goes back to all the questions that are raised if you, with the way the petition is written. But by repealing the other sections, you're also repealing certain parts in every single one of these 9 standards about sampling and analysis. And so I'm just going back to, in terms of if we accept a petition and then that goes off in a separate rulemaking from the rest of it, there's a lot of adjustments that they have to be made as the main rule process is going through, in terms of how everything's written together. So to me, if you take out one part and are repealing some, while the staff is looking at this, the regulations as a whole, you might not get a good coordination. Does this, and one question is, does the staff have to wait until the petition rulemaking is concluded before they, will it delay the staff's progress on the rest of the rule? That's really the question.
Yeah, and to answer that question, it might. And one reason we're making a decision today in May, because I know staff is diligently working to prepare something. I think they're diligently working, but they intend to drop some stuff on us in July. Part of that will be us having to look at the schedule through the committee and through the EMC and whether these two line up behind each other or somehow can be with each other. But that's got to be decided after you guys decide the merits of this request. And then once that's clear, that will give the department and this commission and the committee some things to play with. How do we do the rulemaking? Because there's some things where you can't have overlapping rulemaking. And so some of this may have to be folded in or not. Again, we have great legal minds here. Our executive director is a former administrative law judge. We've got a great attorney sitting here. We got several members here that are attorneys. So I'm confident if you guys decide fairly on what you think the merits of this are, we will figure out a way to adjust schedules and whatnot. I will say this is the first round of air qualities. This is not up against the 2032 deadline. Get council to clarify. So our schedule at this point can be flexible to some degree if we get approval from RRC. So I don't think that is binding us into something with respect to a schedule. We'll have to figure that out. I hope I answered
just
that.
want to emphasize, it's not like these sections that he proposes to repeal is just a number. There's more in each section than just a number.
Y'all have to decide on the merits as an EMC. We do. Any additional questions? If not, after none, I did shut you down, Commissioner Yarborough. I don't know if you're the one to make the first motion, but you asked, so I will recognize you if you have any thoughts, or I'll go to somebody else for a motion.
For the reasons I said before, I would make a motion that we accept this petition.
Okay, we have a motion to accept the petition. Do we have a second? Commissioner Ellison, we have a second to approve the petition. Discussion on the motion. This is among just the commission. Commissioner Smith.
Surprise.
No, we all have to get this out, and this is
No.
better by the debate and the
So,
discussion.
so as I said before, I'm certainly open to the concept of adopting these standards by reference. I think it would benefit for many of the reasons mentioned here from a longer conversation. I would be hesitant to move forward any petition for rulemaking on any subject when it's being inserted in the middle of an existing rulemaking process. I think that is not beneficial to the commission or to the public and can create timing and confusing issues. So I will be voting against the motion because I don't see any benefit to creating a separate rulemaking action when the staff is already bringing forward a proposal that we will have an opportunity to more fully discuss in the context of all the other 0400 air quality rules. And because this particular text is just not sufficient to do what it purports to do. So I think the combination of those two things, I think we would be better served and the public would be better served to go forward with our regular rulemaking process, take it up as the staff brings a draft. I would certainly hope and expect that Mr. Carter would have input in that process, that we would benefit from his insights in that. But it just seems to me that given all the circumstances here, we would be better served to stay with our rulemaking process.
Okay, we have a motion and a second. Further discussion? Commissioner Yarborough?
This is debate with Commissioner Smith on that. I can understand where she's coming from, but on the other side of it, we're always in rulemaking. I don't ever see anybody would be able to come to say anything about a petition, good or bad, with that kind of reasoning, because we're always in rulemaking. I've been in here 2.5 years. I don't know that we've ever finished anything with rulemaking, and we talk about it or we're doing it. So I don't see how that's a.
Hey, it's hard to believe until you experience it, isn't it?
That's
It really is. Everybody can smile at that. It is.
The other piece of that is that if that is the way we're going to go with it, then we need to throw this out because there's no reason that this petition couldn't be.
You made the point. Okay. Further discussion. Commissioner Ellison, who seconded the motion?
Commissioner Yarborough, I'm just glad we're not trying to make session law here because that's even worse.
I think that we are.
And I know Commissioner Smith will be surprised if I disagree with her for a couple of reasons. One, as mentioned earlier, the department is sending a bundle of of rules through the readoption process. That much more work for the committee for a bundle of rules and for the public, and the whole readoption process can take longer. This is a very concise and clearly defined change that I think the committee could move faster on and get out to public notice. It's a very simple and straightforward, relatively easy for the public to understand. So the whole process, I agree with Petitioner Carter, the whole process should be much faster. And it's not necessarily a bad idea, as attorneys like to say, a belt and suspenders approach to have the department continue with their process with this provision entered into each of their rules coming through for readoption. And if this one moves faster, that's fine. I think there's a benefit to the public and the regulated community in that the time it takes to go through the readoption process and get new rules through when they're in a bundle, we could have a new federal administration, a new EPA administrator, and just clarifying that we're following the federal standard, whatever the federal standards may be, prevents us the ping pong ball approach. And we've seen this in other rules, particularly the wetlands definition and things like that, where different political persuasions change the federal guidelines with which we must comply, and simplifying things to say, whatever the feds say, that's what we're going to do. And I think that there are efficiencies in that and benefits to the public.
Mr. Jaspers, I see you have.
Yeah, so
raised.
one thing, I think you, Commissioner Austin, you may have actually just made an argument for staying within the state rules because they're much more stable than, let's say, the potential federal rules that might be ping-ponging back and forth. So having the authority within the state to make the rules, you sort of almost made the argument that that actually could be benefiting North Carolina. But that's not the point that I was trying to make. The question I actually have for my own understanding is, what if the two parallel processes end up in rulemakings that are not completely, in correspondence to each other? What if they're in conflict?
First of all, we have to approve the petition for rulemaking on its merits or not. So let's get that out of the way. Then we're going to have other decisions to make. But as a rulemaking process, 0400 can't be initiated by the petitioner and by the department. So somehow those would have to either be behind each other, these first 400 and next 400, or this would have to incorporate some of the other changes or something that we would have to figure out. That all has to be worked out, but they can't be two parallel 400 2D rules rolling. Commissioner, clean that up for me. I mean, Commissioner, Counsel, Attorney, am I making a mess out of that, or?
Well, I think what we'd do if this petition were to move forward is we would make the 0400, the readoption process for the 0400 rules based on this petition. We just use this as our readoption. We wouldn't ask the department to do it twice. So we wouldn't ask them to get the fiscal note ready on the petition and get a fiscal note ready on the 0400 rules for readoption. We just lump it. We'd make this the readoption for the 2D 0400 rules.
Again, we would have to discuss that, but part of the rules review and readoption is, are they valid, are they applicable, and update the most recent statutory references. So this rule would update some of those statutory references because it'd go with the federal one. So this all has to be worked out. This would have to be worked out on the back end. And that is one reason why we want to talk about it today. If you see merits in granting this petition, the department needs to be aware of that so the committee and the department can work together to put this on the right train.
Okay,
But the petitioner will have priority. If we say the thing,
Okay.
the petitioner's request will have priority.
Okay, so maybe I'm not comprehending this correctly, but to me, it looks like it's almost increasing the workload.
No, I don't think so, but please, yeah. If
We're
that's,
making it more complicated.
yeah, I'm not going to try to talk you in or out of this, Chairman. I'm just going to say, you've got the evidence, you've got the information. Vote with your heart.
Yeah, let's go to vote.
Okay. Commissioner Bailey, an additional question.
Well, just following up on that, because my point earlier was, would this delay the rules revision that the department is going through? But now it's sounding like it would be one public hearing.
It could delay the current, for this first set of rules. There's 7 and they finish before the required statutory deadline to finish rules review and readoption. So there's flex in the schedule that we have. So delaying is a real term. Delayed to what? Delayed to the most recent schedule for this first set of rules? Maybe, but not the whole. We won't risk losing these rules because if we don't review and readopt by 20, whatever it is, we lose the rules. So we will get to that. We have plenty of time to get to that.
But they might be delayed in terms of what the schedule already is, if we have to do this.
It could be, and I'm not going to talk you in or out of it. Y'all have seen the 2 schedules. You've heard the applicant say they disagreed with it. Y'all have to decide. Fair enough? Okay. Hearing. Go ahead, Counselor. Go ahead.
No, I don't think there would be any delay. I'm kind of nod from Mike over there, so.
No, we got a motion in a second. I got to follow the rules on the rules. Yeah, we can talk after about this if we pass it. There's 2 things I do need to talk about after this. If, depending on how this vote, either way this vote goes, we need to talk about some things. So go ahead. So we have a motion and a second. I'll call for the vote. Let's raise your hands because I feel dissension in the room. All in favor, please raise your right hand.
7. Look at it.
How many?
7.
Okay, 7 in favor.
No. Oh, yeah.
Okay, who's opposed?
6. That carries.
Missing 1 year. He's gone.
We're missing her, but folks, well, I have the prerogative. I'll vote for it too. I'll vote for it too. Because I think we need to, for all the reasons Commissioner Yarborough says, as chair, I wouldn't have let it get to this point if I didn't believe in this petition for rulemaking from the private. So I will vote for it too. Okay, so, all right, what is the final tally?
8-6.
8-6. Everybody sufficient with that? Motion passes.
Not sugar for a nickel on that one.
Okay, so let me talk about a couple different things that are coming. First, 2 things in front of us. One is we have the rules review and readoption that the department's going to be bringing, and that's going to have to be, for all the reasons we discussed, that's going to have to be worked out. We had a schedule where we needed to be responsive to this petition. You could have voted it up or down. We voted it up. So now we'll have to figure out how to fold that in and make that work together. Okay? The worst part of this, in one of my minds, was to let this petition somehow try to fight and delay it to where it balled up with the actual rules when we see them and we get into those debates, and that would cloud your potentially proud perspectives on what this meant. So we had a petition that came in. When it came in, we were obligated to respond, and we did, one way or the other. So that's the first thing I'll say. That's with the rule. We also have the 2-hour rules, guys, are coming up. Trust the chair sometimes. I see things coming. The 2-hour rules are coming up, and part of those is what I gave you earlier, is exactly includes petitions for public rulemaking. We have changed that at one point, and I could get into that later. But there are several changes related to this process I would like to change as well. Or potentially change, and we'll talk about those when we get those rules in July, or at least scheduled for July, those draft rules. And then we may have a third, but I do think the statutes are going to bind us on the exact language of what we put in the Federal Register. So I think it's a statute question, not something we can do in our rule absent of the statute. But will have to look at that as a third thing I would like to modify. I'll give you the two things that I've talked about before, just real briefly for the 2L. For the 2L, there's other things. Having been through this, I think there's great advantage you just went through this and some of the questions we went through, because most of you would have to look at 2L with no experience, 2I, without the experience of at least having, some of you haven't gone through declaratory rulemaking either, but you've been asked to change the 2I rules without seeing declaratory rulemaking. You've been through this. One thing that may need to be somewhere is the time limits on the speakers that come before us. It's specified we can grant one each way, but we've done that kind of talking to both parties. So there's nothing wrong with that, but there's not a standard. If we want a standard, we may have to think about a standard to be fair to everybody in the future. The other thing is some of these rules were developed when the committees had a lot more supremacy. And I mentioned this before, you go through a few of these. The way this works, if it goes to committee, the committee chair, without consulting the commission chair, can pick the opposition speaker. And then the commission chair, this actually happened one time, can pick a different person in opposition at the commission level. That seems very backward to me, because I don't want the committee to have a vote, be swayed by or not swayed by an opposition, and then it comes to commission, and then you hear a better opposition view and you vote against it. It needs to be consistent, or at least consulted, and we've tried to manage that, but it is something we need to probably consider, is as we move this from the ones that go to committee first, and again, the chair has the option whether they go to committee or come straight here. But should those speakers be the same? And that's something we'll have to talk about. So those are two things that are very rule oriented that don't have anything to do with this petition, but we'll have to look at as we go forward. Comments from council on any of that? Executive Evans, I'm not going to you, but I think looking long range at the picture, do you have any thoughts or comments on what you've seen here? And as we get ready to look at the air quality rules and the 2I rules, anything you want to add from a perspective?
You've covered it quite well, thank you.
Okay. All right. With no further objection, let's take about a 5-minute break and come back and try to get the agenda finished properly.
My concern is
the EMC back to order from our break. Next item on the agenda is response to RRC objections to pre-permitting construction rules 15A NCAC, the ones we did last time. Let me stop there for a second. I do want to give the opportunity. I think we can work this out offline, but if people still have questions about the previous item and how we work it into rules readoption, we can ask Mike to talk about it or council to talk about it, but I don't want to go too far into it today. But is there questions anybody else want to talk about, or do we need to move on? Okay, hearing none from the commission, we'll work it out in our next meeting or in between. We'll send some emails. Okay. So let me go back and I'm going to turn it over to Ellie in just a second. But as you guys remember, we passed an action at the last meeting in a tie that I had to break as the chair, 8-7. It was mandated by the Senate. After we do that, it has to go to RRC for their review and approval. And long and short of it was RRC had some problems with it. So I'm going to let Counselor talk a little bit about the details of that for a minute. And then I will ask you guys to take one of 3 actions, I believe. So.
All right. So for those of you who haven't really been through all of the rulemaking process so far, after you all adopt a final rule, the rule has to go to the Rules Review Commission for approval. The Rules Review Commission is looking at 4 items, whether we have statutory authority to adopt the rule, whether the rule is clear and unambiguous, whether the rule is reasonably necessary, and whether it was adopted pursuant to the APA's rulemaking process. When they think that we have met those 4 criteria, they approve the rule, and the rule is then entered into the administrative code with some exceptions that are not relevant for today's discussion. If the RRC thinks that we did not meet one or more of those 4 standards, the RRC objects to the rule. When the RRC objects to the rule, the agency has to take one of 2, really 3 options. One, we can try to satisfy the RRC's objection. In other words, we can try to change the rule to overcome whatever problem the RRC saw with it. Second, we can request return of the rule, meaning essentially we're not going to satisfy the RRC's objection, and whatever proposed changes that we made to an existing rule will not go into effect. Any new rules that we were proposing that were objected to will not be entered into the code. Option number 3 is to challenge the RRC and file a lawsuit. That's not in the APA, but that is an option. In this case, for the pre-permitting construction rules, the RRC objected to these rules based on the EMC not having statutory authority to adopt the rules. The reason for that is that the way the session laws were written was that the statutory authority that we need to adopt the rules is not yet effective. It only is effective once EPA approves a SIP amendment. Now, we were attempting to adopt the rules to get EPA to include that in our SIP, and we made the rules contingent upon the EPA accepting and amending our SIP based on the rules, which would have made the statute effective, which would have made us have statutory authority. But the RRC decided that a delayed effective date for the rules pending approval by the EPA was insufficient. And because the statute is not currently effective, we do not have statutory authority to adopt the rule. So the question before you all today is, how do we want to respond to the RRC? I will tell you that in conversation with RRC members and with RRC counsel, they don't see this as an EMC problem. They see this as a problem with the way the legislation was written, which basically means there's nothing we can really do, I don't think, to satisfy the RRC's objection, to change the rule, to make it fit within our statutory authority. We could certainly go back and I can argue again in front of the RRC if that's what you all would like me to do, or we can simply request that the rules come back to us. 2Q0114 would not go into the code at all, and the changes to 2Q0501 and 0507 would not be implemented. The currently existing rules, 2Q0501 and 2Q0507, as they are currently in the code, will stay in the code. They just won't have the changes that would have resulted because of the addition of 0114.
Let me introduce one more piece of complexity to it, just so you got the full view, not endorsing this. But these types of speculative rules or circular rules have been approved by the RRC before, I believe. And so this was either a little unusual or a little specific to the exact piece of legislation that was written, depending on how you want to look at it. But this type of process has been used before and approved by the RRC. So that just mixes it in there. I'm not advising us to go do that right now. But those are our options as outlined by council. So, you know, the 2 extremes, you know, are to let it go. 2 is drag it back, bring it back, try to fix it. And 3, let's sue the RRC over issues that I don't think are worth suing them over. So I'm not going to recommend to this commission we sue the RRC. Okay? And we have before. Don't want to do it again. We can, but if we're going to do it, we need to make the attempt to clean it up first before we go down that path. I think the problem with bringing it back, one of the practical problems is we were told to do it by the General Assembly, but it is difficult to figure out who at the General Assembly was driving this or is behind this, and it's never been used before, even though it was active for a little while. And there are some provisions in there Now, in all honesty, they'd struck out, let me share that, or council may struck it, where they struck out some of the major permit pre-construction type stuff they could do and the letter back to you, but you've clarified that that's not going away.
Right.
So if you follow what I'm saying, and I'll clean that up, nothing's going away, but it looked like they had went into the rule and changed something that we didn't even propose to be changed, and they changed it, but they didn't. I think that was a mistake by the council that wrote it back to us. So since we can't figure it out, since this is a dispute really between the RRC and the General Assembly, I would say let's stay out of that. And if the General Assembly tells us to come back and do it, we'll pick it back up. I would say we have done our duty. I appreciate all the debate. I don't think this is wrong or right. We were instructed, just like we could be from anybody. A legitimate request was made for the EMC. We ran it to ground, and it could have been gunned down at the RRC, as it always can. It could be gunned down at EPA, as it always can. Or the General Assembly we could pass something, they can overrule what we passed, even when they told us to pass it. So I would say my advice to this commission is that we just bring it back and let it die. And if anybody, kind of like whack-a-mole, if anybody stick their head up and say, go redo it, we'll go redo it. But otherwise, just, we're busy, let's let it go. So, council can give you what the motion should be to that, but let's, questions for council or me, or I would say this Executive Director Evans, he's been involved because he's been through this, RRC Administrative Office of Hearings debate many times, so we can ask him questions too. But any questions of the three of us? Yes, sir, Commissioner Anson.
Two questions. Are is it a simple, straightforward legislative deficiency that they cited? And second, related to that, is it something that could be cleaned up in a technical correction bill?
It is a legislative issue. So the 2023 session law just made a change to the statute. In 2024, they made that change to the statute contingent upon EPA approval of a SIP amendment. So the 2020, if the 2024 session law had not been passed, we would have the statutory authority. But because the 2024 session law made the change in statute contingent on EPA approval, we don't have the statutory authority. I'm not a legislative person. I don't know if that could be done in a technical correction, so I would leave that to those who know how that works.
Okay, last question. What would be the venue if we sued the RRC?
Superior Court, Wake
Thank
County
you.
Superior.
Commissioner Bailey.
Well, I've made this point with Director Abrazinskis, but I just wanted to note that this doesn't prevent permittees to go ahead and do many activities prior to the permit issuance. They still have all these abilities to enter into contracts, to clear the land. There's many things they can do. They can even buy the emission source and put it on the property. So it's not really hampering what permittees already have the right to do.
And council's clarified that too, for the record. So yes. This would have been another tool in the tool bag that may or may not have ever been used. That's what we said before, but.
Okay, so I stepped in a bit late.
No, what? No, but it's fine. Questions or comments over here?
So I guess to clarify, it sounds like there's no appetite or really much basis for pursuing an appeal of the Rules Review Commission objection. So it really comes down to, do we not respond to the RRC at all? In which case, if we don't respond within the time allowed under the statute, the rules automatically return, I think.
The RRC returns.
They return the rule.
They modified it, so they automatically return it.
Right. And so our other option is to send a response to the RRC to say, we cannot resolve the objection because it's beyond the commission's authority to resolve. So it's really, do we send something back to them explaining why we're not doing anything? Or do we just let it lie, in which case it's going to die a natural death anyway? Is that accurate?
We're required under the APA to either try to satisfy the objection or submit a written response indicating that we have decided not to change the rule or adopt the new rule. Those are the requirements. There's an outlet for if we don't meet those requirements, the RRC will just return the rule to us. But I think we have an obligation, since we are discussing about it, to make a decision as to whether we're going to try to satisfy the objection or request that the rules be returned.
Right. And as chair, I'd like this whole commission to, since we're going to write a letter, if council's going to write a letter, we need I think it's appropriate to have a vote of the whole commission, so we're all behind the action we're taking and not just have council do it without the endorsement of the full commission. I think that's the way to do it. Commissioner Tweedy.
If somebody will tell me how to say it, I'll make a motion.
Okay. Do you know what you wanted to say?
I don't know why we're still talking about it.
I think it would simply be, we've decided, the motion would be to respond to the RRC saying we've decided not to satisfy the objection and request a return of the rules.
Okay, I move what council just said.
Okay. She's got it written down.
I'll second it.
Yeah, motion by Commissioner Tweedy, second by Vice Chair Reardon. Any discussion on the motion? All in favor, say aye. Aye. Any opposed? It's unanimous. Motion passes. Okay, very good. Thank you, guys. We're at about 11:10, almost 11:15. We've got I want to do a status report from our executive director real quick. We have no items shown there, but 3 questions here, just, or maybe 1 statement and 2 clarifications. Director Evans, it seems like, I know I feel like you've been here a year now, but you've been here now about 60 days. This is your 2nd meeting. It's amazing, isn't it?
54 days.
54 days, okay. Wow. He's counting the days. So welcome to the show, as it always is, and it does take you a couple months to really learn what you've gotten yourself into, doesn't it?
Yeah, yes, sir.
Okay. 2 things. I know you've been working on this, but talk a little bit about 5 things we had talked about previously, but the gap analysis and the things we're charted to do and the things that we're addressing. Don't have to go into a lot of detail, but give us an update on that. And when it gets in draft, we can send it to everybody. And then anything you've seen already on process improvements, just kind of grabbing that out of the air off the fly, because that was the 5th thing we were going to talk about on process improvement. So talk just a minute about what you've done so far on the gap analysis.
Right. And well, let me just give the 5 things that the chairman has charged me with. And that's the first is to support Secretary Wilson and his goals. He's got multiple goals. The one that I connect in most readily would be the emphasis on emerging contaminants. And we continue to do that in committee. I presented some information in the committee yesterday. So we're still working on that issue consistent with the secretary's goals. The second one is the gap analysis. And that's to try to identify all the obligations of the EMC, determine whether we have delegated that and the extent of our delegation. I have got a spreadsheet. I'm up to 112 individual charges from the General Assembly to the commission. And for each one of those, I'm tracking the delegation, what has been delegated. It's pretty complicated because we've got 40 years where the EMC has been charged with a activity and a responsibility. They've delegated some of that or all of that, depending what the program is. And then the General Assembly comes in with session laws and changes those delegations as well, names the department or the EMC. So pretty complicated, but I've got 112 so far. I'm still working on that. The third one was to identify gaps and to close those gaps. So it's related to this gap analysis. And so when we do that, I'm going to come back with some suggestions about how we might improve the ability for the EMC to satisfy their obligations and to track them. The fourth one was to hire staff. I certainly hope by July I'll have at least 1 or 2 staff members hired. We're working on a position description right now. The last one was Chairman Solomon gave me 120 days to suggest some workflows. And to be honest with you, I've already identified a great number of those. Watching this, the committee and the committee meetings and some of the questions that were raised, I think there's some opportunities to try to improve that process flow so that we work as an EMC closely with DEQ and maybe get that process a little more consistent. So that's where I am right now on those 5 goals.
I use the word formal, but and I think that'll be the test when workflows are very hard and they need to be prescriptive, but sometimes you need to be flexible too.
Yeah.
Because everybody's got a lot of demands on them and we have to be flexible at some levels. So, we need to map them out where we need to, but John will identify those and bring them back to us. Some of those he sees, and then we may have others from commissioners that we'll see. So, I don't know if we'll get all 120 done in 120 days, but we'll make good progress.
We'll make some priorities and get those in place.
I also mentioned to you, and I think we'll do this, Commissioner Bailey and I have talked for the second time in 2 years. Our EMC, we have a hard time connecting through, I'm gonna call it Dremel, but that's my saw. But the system that we use to post the minutes with, other commissions within DEQ, and we've talked about this for several years, just hit the agenda button and it pops up. And we have to go through the Laserfish thing, and that gets disconnected sometimes. And y'all have been very frustrated, some of you, with being able to get your materials on time because the Laserfish doesn't work out. I know Lois gets frustrated with that too, and staff gets frustrated with that too, as well as commissioners. So Commissioner Bailey has once again asked me, and I'm not asked, I'm gonna commission you to work with Director Rogers, because that's where we started last time, and if we have to go further up, we will. But somehow we need to be able to get our information similar to what the other commissions do. Either they need to migrate to this Laserfish and go through the pain, or we need to drop down and do, is that paraphrasing Commissioner Bailey? Is that what you want? Yeah. Okay. So anyway, yes.
So I think it's great that you're tackling some of these issues and, it's helpful you coming in new, even though you have a little bit of familiarity, you're still bringing some fresh eyes. One thing I would like to suggest and encourage, especially in looking through, workflows and other thoughts, set up a time with every single one of us and make sure that you hear some observations that we have. And kind of factor that into your processing and what you might bring back to us.
Yes, Commissioner.
Yep. Okay.
Thank you.
Any other questions or comments for John? Okay, hearing none, for our next section, we've got 2 information items and concluding remarks. So let's try to get this done by noon, guys. Just the spirit of things. Let's try to move that.
You don't want to go to 5:30?
No, we're not gonna go.
We have revisions.
Yeah, you may go to 5:30 today. Your missions, civil missions 1. Just to inform the council, some of you have not even seen civil remissions yet, and it used to be we had civil remissions group 1 and 2 meet after every meeting. And I asked some questions about a year ago, where are the civil remissions at? And then today, I think 22 of them dropped out of the air. So civil remissions 1, you've got 22 civil remissions to deal with today. So we'll try to balance that out better in the future. It may have been part of circumstance here, but anyway. Okay, so Falls Lake IA program extension. Counselor, are you doing that one, or we have John Heisman? John's here. Come on up, John. Well, there's a legal interpretation.
Good morning, Chairman Solomon, members of the commission. Again, I'm John Heisman. I work with the non-point source planning branch here at the Division of Water Resources. I don't have a slide presentation today, just some talking points about the IAIA. That's the interim alternative implementation approach in the Falls Lake watershed. What that is that relates to our nutrient management strategy for Falls Lake. We have the existing development rule. The existing development rule in Falls Lake requires under stage 1, which is the implementation stage we're in now, for the local governments in the falls to offset the nutrient loading from development that occurred between 2006 and 2012. 2006 is the baseline period for the management strategy. 2012 is when our new development stormwater rule went in. So the idea is local governments would implement projects to offset the loading for those loading from development between 2006 and 2012. The IAIA is an EMC approved compliance pathway for the local governments to meet that requirement. What that IAIA program was, is it was done through a collaboration by the UNRBA, the Upper Neuse River Basin Association, that collection of local governments and falls, working with DWR and NGOs like American Rivers in the watershed to come up with this alternative approach to how local governments can comply with the rule. What the IAIA does, that interim alternative implementation approach, provides a alternative to the traditional pounds accounting approach, where you would calculate a jurisdictional load and calculate credits for different practices that would go towards offsetting those loads. And that we had a lot of complications and agreement on how those loads could be calculated, how the credits could be calculated. And this IAI program provides an alternative to that, where they instead have a more flexible investment-based framework to meet the rule requirements. And essentially, through the IAI that was approved by the EMC back in 2022, the UNRBA local governments got together and created a formula where they would each have specific annual investment commitments that they had to meet each year in terms of monies invested in water quality improvement projects that they would implement in falls. Collectively, that investment commitment for the 13 local governments was 1.5 million. It's different for each local government depending on how much of a footprint they have in the watershed, how much water they withdraw from the watershed. Some of the biggest investment commitments come from like Raleigh and Durham. Durham having a big footprint in the watershed, Raleigh being a water consumer in the watershed. But collectively, they have to implement 1.5 million. Another benefit of this IAI was it got things moving. It kept implementation of practices, water quality improvement practices, ongoing in the watershed while we went through the falls reexamination process and we worked for the rules readoption process. Another benefit, by focusing on an investment-based approach and getting away from pounds accounting, it allowed us improved flexibility on the different types of practices that the local governments could implement to get credit. So they can do things that obviously we do have pounds accounting that can be done, but it provided flexibility for other water quality improving practices that we don't necessarily have pounds accounting for. Things like doing land preservation or different programmatic measures like education on fertilizer management or taking care of on-site wastewater systems properly and doing proper pump outs. So it got things implemented, it got things going, it expanded the flexibility and provided this more flexible framework for implementing the process and implementing practices. And I will say that the UNRBA local governments have been doing a great job. They've been implementing since 2021. They aligned it with the fiscal year of each local government. So they started implementing in 2021 in advance of us bringing the program in 2022 for final approval by the EMC. They're wrapping up their 5th year of implementation. The 4th year annual report came to us in November, and they have to implement, again, 1.5 million each year. And they've been meeting and exceeding their investment requirements, where at this point, they should have implemented $6 million collectively, and they've implemented $16 million worth of practices over those initial 4 years. So it's been a big success in terms of implementation and getting that investment in the watershed. And the original 2022 IAI approval, that program was for a duration of 5 years, going from June 2021 to July 2026. So when the UNRBA submitted their latest annual report in November, they also submitted the modified IAI program and a resolution to extend it, because that's when we presented the IAI to you in 2022, we basically recognized that 5-year duration and recognized that the program could be extended based on the rules readoption process, and that the UNRBA would simply have to submit that modified program and resolution, effectively extending it for another 5 years or until our Falls Lake rules are readopted, whichever comes sooner. And I do imagine our readoption is going to come sooner than in 5 years. But I just wanted to give you an update on what the IAI was, how well it's been going, and the investment that's been made by the Upper Neuse River Basin Association local governments, and just highlight the fact that we consider this a positive story, a success story. And so much so that as we were working on readopting the rules in Falls Lake, we do plan on incorporating this investment-based approach option into the existing development rule as an option for local governments going forward. So codifying this option in our rules to keep it going. And other watersheds like in Jordan Lake, they have expressed interest in also codifying that same investment option in their existing development rule as they bring their rule package forward. So with that, I'll pause there and happy to take any questions that you may have.
Mr. Bumgarner.
Taking liberties with the definition of credit, you tell me, but who's assessing the credit for these practices, and how do you determine that an educational meeting on fertilizer or some buffer or whatever, what credit level that is? Or is it they just spent money and that's the credit?
That's the credit. That's this whole framework for the IAI is about investment. So that it got us away from trying to quantify pounds credit for everything they're doing. And the idea was to expand it to a lot more a flexible list of eligible practices that we all recognize have some level of water quality improvement, even though you might not be able to quantify what that is. Like we got really wrapped around the wheel for several months about land preservation. And we all agree that land preservation is a great practice for protecting a watershed, but quantifying a pounds reduction was very, very challenging. But they get credit from a dollar perspective for the investment for those programmatic measures and practices.
Commissioner Ellison. Follow up, Commissioner Montgomery.
So is there any quandary between they spend $1.6 million on one preservation site versus 5 other projects? Is between DWR and UNRB, is there some quandary between that? Does everybody just agree that whatever the money's spent on is just good?
There's been general agreement because typically, like the way the II works, they could technically pool their money together and fund a big project, but all the local governments expressed interest in funding projects locally within their jurisdiction to get those improvements. And there hasn't been any one practice or project that's like dominated. Like this last reporting cycle, there was like 30 different projects done, and they ranged everything from land preservation to, repairing infrastructure like leaky collection systems, doing education for on-site wastewater systems, or actually implementing some, actual SCMs as well. So we haven't seen anything like that where there's just one big lump sum and not much else being done.
Mr. Ellison.
So you've been at this for about 5 years. Is there any quantified benefit to water quality in the lake?
Well, that's part of that bigger picture that we were talking a little bit about yesterday. I mean, right now we're in the Falls Lake rules have been implemented since 2011. Different aspects of those rules have been coming into place since then. We have not seen improvement in the water quality standard, meeting the water quality standard in Falls Lake through the latest 2022 use assessment cycle. So there's still several parts of Falls Lake that are not meeting the standard, but that kind of gets us into that larger argument that we were getting into yesterday about the wastewater, about what the different sectors are doing and whether that chlorophyll standard is the appropriate standard, which the UNRBA, has been bringing up in several of our meetings. And as I highlighted yesterday, one of the other aspects that we're addressing in our rules readoption is putting in a process commitment in the purpose and scope rule for Falls Lake for revisiting the chlorophyll standard for a site-specific standard at Falls Lake. But the short answer is, the IAI is just one part of the reductions for the management strategy, and collectively for Falls Lake, while we've seen decreases in loading to the lake overall, we haven't seen the lake respond as well as we'd like to at this point.
Does your monitoring program allow you to monitor in the vicinity of any of these different investments?
It's not set up specifically like that where we have project by project monitoring going on. I mean, typically in Falls in the past, we have monitoring stations just at the 5 different tributaries that are feeding up in the Upper Falls watershed. That it's like the main loading to the lake. I mean, that captures about 75% of the flow into the lake. And that monitoring is where we kind of do our trend analysis, looking at the general trends in loading to the lake, but we don't have project-specific monitoring.
So you can't document any benefit to these investments by the taxpayers?
What we do ask is when the UNRBA does invest in a project where there is some sort of quantification method that's already in place for a practice, like if they're doing a stormwater practice that we have calculation methods for, or there's different research we do ask that they keep track of those pounds credits that would have been associated with those investments. So, but we don't judge the compliance of the IAI on pounds. We judge it on the investment.
Right. But you can't prove that anything has been a good investment.
Well, we don't have definitive information, but like, again, they do track pounds where they can, where they are quantifiable.
Okay. All right, let me ask these questions. So the Falls skipped the last round of readoption. So it's last, as you mentioned, 2011 was their last, was when the Falls rules were put in.
Yes.
Were they readopted in the last cycle and the?
Well, no, because so there was that legislation that
I
formed.
understand. That's where I'm going. So this program was that, and I know this program's been popular or supported. I'm just trying to get to the fact of this program's not in the current rule right now. So sometimes it's an MOA or MOU between the parties to do this. I assume it's supported in law somewhere if it's not in rule.
So the way we talked about it back when we brought it was that the rule, like there's a trading rule in Falls Lake, and then there's the existing management rule, existing development rule. And that trading rule like allowed local governments individually to like combine their existing development requirements and their point source requirements. And the existing development rule allowed local governments to join collectively to meet the requirements in a collective manner. So like cobbling together those different allowances within the rule, we felt provided a pathway for a group compliance option to meet the requirements for the rule. And that's how it was presented back in 2022 under those elements of the existing Falls Lake rules. And it seemed to work up to this point, and that's why we thought it was important to, going forward, to actually codify the actual II framework and eligible practices and how it would operate within the rules itself, instead of relying on just a couple of different provisions in the existing rule.
Okay. And then again, I'm not speaking against it, and I was part of this commission when we did it. I'm just looking at rules readoption right now and some other issues that are going. So my question is it working? Is it working because EPA doesn't know about it? Is it working because it's not in the rules? Is it working because everybody just likes it and we all agreed to go do it? I mean, you say it's working. Nobody's complaining about it, I guess, right?
Nobody's complaining about it. I think everybody is happy that things are being done instead of us all arguing over what the jurisdictional load should be or how much credit you get for XYZ practice. And instead, it keeps, people operating in good faith, doing practices that we all believe have a positive impact on the lake and the watershed while we work on this rules readoption process, instead of waiting 3-5 years until the rules are done and then implementing something.
Right. And my understanding is this is not an action item because the way this was put together is the director and one of the former chairs signed this. So now the 5 years is up. So we just need to acknowledge by signature again that it's ongoing, but this body does not need to take any new action to renew it, so to speak. It's just goes on in perpetuity as long as the commission and the department recognize it's still going on. Is that where we're at?
Yes, that's correct.
Okay. It's my questions. Any other questions? Okay, so at this point, Director Rogers and I will figure out who signs it, or if we both sign it, and we'll just acknowledge that you're hard at work and everybody likes it, okay?
Okay.
All right, sounds good.
Thank you
All
very
right,
much.
Thank you, John. All right, 11:30, flood resiliency blueprint update, and this says update, but I know there'll be some questions on this one, but who's giving this? I don't see it now. Oh, Kathy Dello.
Good morning.
Welcome.
I do.
Sorry about that. I was downloaded earlier, not sure where that went. This one, okay. There you go, sorry about that.
You're fine. Good morning, everybody. Chair Solomon, thank you for the invitation. I'm really pleased to present an update on the flood resiliency blueprint. And I hear you loud and clear. You want to be out of here by noon. I'm in your way for lunch, so we'll go through this pretty quickly.
You only have about 15 minutes.
Yes.
These other division directors have 15.
So what are we trying to do? We're trying to make North Carolina more resilient to flooding. This was legislation that was passed by the General Assembly in 2021 following Hurricanes Florence and Matthew. But those of us around the table know that North Carolina has flooding problems regardless of hurricanes. There are the storms that drop 3, 4, 5 inches of rain and simply ruin our day. But luckily for us, they gave us a few more guideposts besides just make North Carolina more resilient to flooding. We are meant to be the backbone of state flood planning. We are authorized right now to work in 6 basins. 5 of those are in Eastern North Carolina. Those were in the initial legislation. And then in 2023, in the Farm Bill, the General Assembly added the French Broad River Basin, which was an extraordinary foresight on their part because we obviously saw what happened with Hurricane Helene. And what we're meant to do is reduce the cost and complexity for planning for flooding in North Carolina. This means that your Burgaws have the same tools and access as your Raleighs and your Charlottes. We want everybody to be able to implement flood risk reduction projects and also prioritize the projects that are best for their community. Now, we talk a lot about the blueprint tool and you'll see those updates, but what we're really meant to deliver is a prioritized set of projects that the state and local communities can implement. So we'll go to the General Assembly this summer and we will give them a river basin action strategy, and I'll talk a little bit more about that, but we'll say these are the 10 projects in the basin that can really deliver the most bang for the buck. We're also trying to work strategically in these basins. We know that water doesn't stop at town borders and passes through, and that sometimes flooding upstream causes problems for folks downstream. So we're working as a whole in the basin. We have staff members located and living in these basins, kind of acting like extension agents to help the local governments prioritize the projects, but also figure out which ones are going to deliver the most resilience for them, but also minimize the cost. Now, we have done a lot in the past year or so, and my colleague Stu Brown, he's the Flood Resilience Blueprint Coordinator. He is not here today, but we were lucky to hire him from Louisiana. He was the lead on the Coastal Master Plan there, and the legislature told us, look to Louisiana. They have some really good ideas for planning and flooding, so we went and hired their guy away. And Stu has been hard at work. We released new floodplain maps in March 2026, and I'll show you some of those slides. The tool was released last April. We are doing trainings. Every single mayor, local official, anybody who wants a training can come and sit down with our staff. And we're doing local planning and basin support in all 6 basins. The river basin action strategies will be completed this summer and delivered to the legislature. And we have funded 74 projects, and that number keeps going up every single day. Now, North Carolina is a data-rich state. We don't have to reinvent the wheel here. There's a lot of data that we can pull from our sister state agencies, from here at DEQ, from federal agencies, from our university partners to support resilience planning. In some cases, we have had to develop new metrics. We've worked with our colleagues at DOT to look at flooding impacts on roadways, but we didn't want to recreate anything that we already had. Like I said, we're trying to minimize the cost of flooding to the state and communities, and we didn't want to drive up the bill doing things that already exist. But one thing that came up over and over and over when we went to communities was that the flood maps are out of date. A lot of them were referring to the 100-year floodplains that FEMA uses to set National Flood Insurance Program prices, but they're not an accurate picture of their risk. I've had many mayors point to streets in their town and intersections, and they say, Kathy, this floods all the time, and it's not in the floodplain maps. So we walked away, we got with North Carolina Emergency Management, and we said, we've got to do better for our people. We know that buildings outside of the floodplain flood frequently. 2 studies, one from NC State, show that almost 70% of flood damage reports in 2020 were outside of those floodplains across the country. And then Chapel Hill found that over 90,000 buildings have flooded at least once from 1996 to 2020. 43% of those were outside the FEMA floodplain, and some of those buildings have now flooded multiple times. So we've got a really big problem on our hands. Now, this is a picture of our floodplain maps that we released on April 1st, and the blue is the FEMA regulatory floodplain, the one that we always think about, talk about, know about. When FEMA maps floodplains, they essentially just map the river getting bigger with more water. But what we did here is we added pluvial flooding. So the places that flood when you get those 3, 4, or 5-inch events that don't show up in the FEMA floodplain maps. We also went ahead and said, okay, we know these aren't representative of risk, worked with EM. That's the pink. Those are advisory floodplains. They are now in the blueprint tool. They are meant to be a guide. They are not law. They are not rule. People can use them or people can't use them. We do have a number of folks who are thinking about procuring private flood insurance or elevating structures, and they've appreciated access to these maps. We also work really closely with DOT and Ag, and they are using these blueprint maps as well. And just as a proof of concept, we're in Carborough here. Last summer, we had Tropical Storm Chantal. We would expect the flooding from that storm to be in the blue, but we saw pretty significant loss and damage in the pink, which we would say would flood in an event like Chantal. The picture on the bottom right is actually their public works building. That was about $1.5 million in uninsured loss for the town. So obviously flooding is costing our folks a lot of money, and we just want to help make things easier for them. Now, the blueprint tool is often what we refer to when we talk about blueprint. It's a resource for communities. Like I said, every community in the state is having access to the same things that the big cities get, the Raleighs and the Charlottes who can afford some of this work. And it's providing users with accurate data-driven flood risk and vulnerability assessments. We know our small communities maybe have 1 or 2 staff that are on emergency management, and they are dealing with absolutely everything. Resilience is one more thing that they have to prioritize, and we're trying to make it as easy as possible for them. And the way we do that is we allow the users to go into the blueprint tool and come up with a concept and explore how it might work in their community. How much might it cost? Will it actually make a dent in flooding? How complex is it? And how would it score in that list of projects? This is where other states have been coming to us and saying, this is super innovative. You know, floodplain maps exist. They exist in public space, they exist in private companies, but what we're doing here is reducing a lot of the workload for our local governments. And the tool website is right there if you want to go and play around on it. Now, all users can go in and look at the floodplain maps and look at community profiles. Like I said, we've pulled in other data from our sister state agencies, and you can learn a lot about what's at risk in your community or at your home if you're in one of the 6 basins. Our partners have special access to developing those vulnerability assessments and plans because we wouldn't want somebody purporting to be the city of Goldboro and doing planning for the community that they didn't authorize or want themselves. That being said, if any of you all want to see that part of the tool, we're happy to provide access, or like I said, sit down with our staff and walk through it. Now, going back to the legislation, we have to present this prioritized set of projects and funding strategies. The tool is great. The tool reduces a lot of work. The tool is not magic, unfortunately. It gets us to a point where we have this big block of flood resilience actions and concepts. And in the tool and in the strategies and what we're collecting are things that have also happened in the past and been identified in the past. We cannot keep going back to communities after every single hurricane and saying, what do you need? What project do you need? How can we fund this? So we're pulling all of those and bringing them into the strategy, saying, hey, if there's money available, this would be a great project to fund. The community's already identified it. Then we narrow down into local planning. We're working really closely with those communities. Those staff that I identified are all over the basin, like extension agents. And then we're bringing the basin together because, like I said, water doesn't just stop at the border. We are helping folks get to feasibility, engineering, and design, and to implementation. We aren't just funding these projects through DEQ. We're working with other state agencies, other programs like the Land and Water Fund, like Department of Ag STRAP program to help get the money out the door. And this summer, the General Assembly will see the River Basin Action Strategies. Like I said, it's a data and gap analysis and inventory of actions that have already been identified. The vulnerability assessments that we've put together through the tool, capacity assessments, even though we're trying to reduce the barrier for those smaller communities, they don't have the capacity that some other communities need, and our team can help bridge some of that gap if we know about it. And we have money to pass out for projects. And like I said, we're doing that through our sister agencies, and we've gotten 43 million out the door. But in the blueprint tool is also a way to access other funding. So we know that we need to rely on other sources, other state agencies, other federal agencies to help folks in these communities. These are our timelines. The 5 Eastern North Carolina basins will be delivered this summer. The floodplain maps were released on April 1st. We tried really hard not to do it on April Fool's Day, but we did. And the French Broad is a little bit behind because post-Hurricane Helene, we had to go back to the drawing board, do remodeling because we know that the geomorphology changed significantly up there and we want it to be as accurate as possible. Another thing we had to consider is that a number of the folks that we work with are actively involved in response, and we don't necessarily need to be nagging them about our strategy when they're just trying to recover. So that one will be coming a little bit later in the year. Looking forward to delivering that and happy to come back and talk when those are out. And this is where we have funded the projects across those 5 basins. We are trying to get them in a wide array of communities. We are working diligently with local partners. We're trying to assess the gaps. And like I said, we funded it through our sister state agencies, DOT, Land and Water Fund, STRAP, and a number of other groups. And I know I am coming up on time, so thank you for your attention, and I'll take any questions.
Questions for Assistant Secretary Dello.
I have one question, if I might.
Chair Reardon.
Yeah, this is just absolutely great work. Thank you for your presentation on time, and thank you for what you covered. I do have one question. When we look back over at this latest disaster that we had with flooding, there's a lot of lessons learned, right? That's
Yes.
what we learned. Is in this part, do we identify those regulations and rules that need to be waived during a disaster response? I know we had a lot. We even had some with the charring issues, right? Where we worked with EPA and the department to be able to use these chars. Do we capture any of these rules, no matter which agency they reside in, that need to be waived or something in that regard?
We haven't in the way of capturing them as if we need to reevaluate or assess how they're being used, but they have factored into some of the strategies.
Because what I'm concerned with is we put all these rules in place for some sense of normalcy, when we're just doing what we do every day. And then a disaster comes along like we recently had, and then these rules get in the way of recovery. And then these agencies are trying to navigate that independently, and maybe we need to capture a summary of these rules and how long that period of time was that they are waived or modified in something. And then the General Assembly can help us with some of that if these agencies can't do it on their own. I think these rules can get in the way of our response and to be able to recover in a timely way. And sometimes the regulatory agency is the biggest problem you got, right?
Yeah.
And how do we navigate that? That's the only thing I would say to you. Bill, you lived this firsthand up there. And so I'm just trying to tie on to some of the things I hear you say. I'll give the department credit. They have done that, but we still don't have it codified. That would be, what he's saying would be a huge thing to do 2 things, in my opinion. One is, the disaster's not over till the money runs out or the project's done. Because anything else is stupid. Put a 60-day, 90-day, keep extending it when it needs to have 2 things. So that would be, what he's mentioned is be very helpful.
Noted.
Best example of that is the fire department comes to your house is on fire, and they get a permit to knock a hole in the roof to put it out. They don't. I think we need to look at that as a way to working on our regulation.
Commissioner Tweedy.
I feel like I should know the answer to that. It's actually a similar question, but different angle on it. Does the blueprint veer into any regulatory recommendations as part of its work? I should know the answer to that, but I can't.
It does
say
not. This is all advisory. It's all voluntary. Nobody has to use this.
Okay, my only point is North Carolina, I think, is still one of the fastest growing states in the country. So we're putting millions of dollars into resiliency projects, and then we're trying to pave the world as quick as we can as well. So those 2 things need some balance.
And I guess two questions or statements maybe. One is, one of our charges of the EMC is to work with local government on flood education. So that's been there for a long time. It roots back to stormwater issues, I believe, and other issues we do like wetlands and those type of rules and regulations. So with that said, it would be very helpful to have, we also do river basin plans too, and you doing a river. It gets to be very confusing, doesn't it?
Yes.
And I know some of that's folded in and worked together, but this EMC doesn't see that. So it would be very helpful to have you come back on a more regular basis, since this is one of our charges, and we are changing, we do have our own river basin plans, and we do have our own stormwater rules. And of course, some of the flooding you're talking about is truly from flooding, and some from bad stormwater. Outdated stuff in towns that should have been
Absolutely.
dug up and redone again. So, I got a little problem with start mapping things and saying it's a floodplain. I know it floods, but it also just takes one project to fix that, and the local government sometimes don't. So we need better coordination with you, and I don't want to volunteer our water quality, our water allocation committee for this without talking to the chair, but I will suggest you volunteered us a sneak peek at the map. Maybe we can run a special session or do it through the committee where this commission can see that as a tangible thing to look at your mapping tool, so we understand that a little better.
Very happy to do that.
Okay. Commissioner Ellison.
To kind of build on what's been said, in addition to clarifying how state regulations can be managed in an emergency situation, I'd suggest that memoranda of understanding with the Corps and EPA would be very helpful, especially at like Helene level responses. And I know both of those agencies were indulgent and very cooperative, but there was an end, particularly at the Corps, that's the one I know the most about, there was an end to their support. The other thing, as Chair Solomon said, we're involved in basin planning, and commissioners are liaisons to various water basins. So I'm the liaison to the White Oak River Basin, and I haven't heard from you guys at all. And I don't know if any other commissioners have from the other basins, but some of us have extensive experience in these issues, and we'd like to know a little more detail about what you're doing.
Yeah, that's an oversight on our part. Connect more.
Vice Chair Reardon, one more question.
One more, and maybe a foolish question, but I continue to hear that our regulations are impediments to cleaning out the streams and the creeks. And if we can't clean out the streams and the creeks because we can't remove the debris from the storm from it, then the next flood's going to be worse because that water's got to go somewhere. And thus some of the snatch and grab kind of programs you have to pull the debris out of it, but you can't completely get it out of the stream. You got to pull it up on the bank. Then the next storm washes it right back down into the waterway. Do we evaluate what some of the impediments that the rules that we have for environmental management is contributing to these flooding issues because of our impediments and inability to clean out these waterways?
We haven't through this process.
But I'll stop because I know
Mr.
something's
Smith.
coming.
I know, we're going to have her back, so go ahead.
No. So I was just going to say, to follow up on that, that has been an issue every time the state has experienced a major flood event. And largely the impediments are federal rather than state. They have to do with 404 permitting because the stream bed is impacted by the activities required to remove the debris from the stream. So it can be done, but many of those projects, if they are using heavy equipment and are, potentially disturbing a significant amount of stream bed, require Army Corps of Engineers approval. And so, that's one of those things we try to work through after an emergency like that.
But it's not working. Our floods are more devastating today in the history of my time here on Earth, I guess. And we continue to see it get worse and worse and worse. And we know that water either runs in a creek or a stream or it runs down a highway. But it's going to do one or the other. But every time you cut the news on, you see these flooding events, and we've not resolved the core issue of cleaning out the streams and the rivers. But other than pull it up on the bank. I know this is not the place for this.
Yeah. Let me say this. We worked, Commissioner Yarborough has worked with departments, so have I, about emergency response and codifying that. I don't know if you've been in the picture with the Office of Resiliency with some of that maybe on the fringes. We need more interaction with you, so we'll look for way. And Executive Director Evans is a staff member, and he can work with you to have you here or to work on a format to see you more.
That sounds great. I'm happy to visit as much as you want me to.
Okay. Thank you.
Thank you.
All right, let me move on. Huh?
No, you good.
Well, you're the one saying, let's go.
I
And
know.
then you going.
I'm getting riled up on it.
I know, I can see, I
But
can
that
see.
ain't the right place. I got it.
Speaking of getting riled up, let's go over to director comments now with our main business. Main business over. Toby, up to you, buddy. Come on up.
You got 5 minutes.
Good afternoon. I'll keep it
You can
short.
go past noon. I knew we were. It's okay. But we try to keep the schedule a little bit on track.
No worries there. Still good morning, members. Glad to be with you today. Just got some quick updates for you for our dam safety section and within Demler. Demler has presented the O2K dam safety rules to the Water Allocation Committee on May 13th yesterday to request to go EMC approval for its July 26th meeting. The regulatory impact analysis has been approved by OSBM. Mr. Jacob Smith provided informational updates on this process back in March. In the meeting in May, no additional presentation was provided other than just facilitation for some quick questions and provide some quick additional information by Adam Parr. With the upcoming request to bring this back to the EMC's July 2026 meeting to approve the proposed rules and physical analysis to proceed to public comment and hearing. In the March meeting, water allocation members had questions regarding aspects around 2 rules addressing qualified engineer as it relates to NCGS 143-215.25A, subsection A8, which was a recent amendment to the dam safety law and incremental damage analysis as it relates to hazard classification on the basis of environmental damage. Both were addressed appropriately for the needs to proceed through rules readoption. Demler will endeavor to work with the commission members to address any others that may come up prior to the July 2026 meeting, where Demler will request approval by the commission to move to a request for approval of proposed rules and fiscal analysis in order to proceed to public comment and hearing as proposed by the committee in order to keep this rule on its approved schedule. Also, one other thing is, as it will be a very tight schedule moving forward, not asking for any appointment for hearing officer at this time, but just sort of keep that in mind that we will need to identify a hearing officer as soon as possible once it does move through the EMC. Also, dam safety program, most of you are aware that we did receive our first time dam safety grant as a result of Hurricane Helene recovery funding. That $10 million went through an initial notice of funding opportunity. We received 21 applications with that. We initially had 7 which came through and were qualified and determined to be eligible at that time. The 21 total applications were requesting $21.7 million. We only had 10 million right now in the budget to be able to provide those awards. One of those 7 had to back out, and they'll look like they'll be reapplying because they had to address a few other things on their end. But we have a second notice of funding opportunity to finish out to try to spend that remaining $2.7 million. And that NOFO deadline is June 19th. We provided 120 days on the second round to provide multiple other applicants to provide their applications and give them time to get designs, et cetera, put together for their applications. We are expecting to see another Helene Recovery Award. We're still waiting to hear from that with the General Assembly, but fingers crossed that there'll be some additional funds for dam owners in North Carolina to help provide for the safety and recovery of West North Carolina as a result of Helene. With that, that's all I have. Any questions?
Question for Director Vincent. Commissioner Yarborough.
Yes, 2 things. One is you mentioned about the farm ponds and the dam.
Yes, sir.
But that's in addition to all of North Carolina, that's a big concern of mine, is that we have developments above these watersheds. Then it becomes high risk, maybe a 50-year-old dam that's been there all this time. And then you have, I don't know that we don't need to look at that at some point to make that address. It's not the farmer's fault or whoever's on it. All of a sudden, it's their responsibility to have to do it, their money. Second thing, I'm still waiting on that MOU, the department to work with them on water, and I would very much like to see that happen. The attorney says that it's done, but it's not got to the department back.
And I'm waiting on that because my understanding that it's done too, and I don't know why it hasn't gotten there, so I'll look into that for you. And on the first matter, you and I have spoken on that, and we've actually, started some initial meetings with the Department of Agriculture just to get their input on those same concerns.
Can we get that as an information item before the commission at some point?
Thank you very much.
We can, yes, sir.
Okay, thank you.
Any other questions? Glad to be with you today.
Thank you very much. Director Scott.
Thank you, Mr. Chairman, members of the commission. Hope everybody's doing well. Did want to thank the groundwater committee members and the DWR and DWM staff. We're working our way through those historic IMAX, interim maximum allowable concentrations for the 2L rules. So a lot of great work on that front and great discussion yesterday. A few division updates. Our long-term section chief in our Superfund program, Bill Heineke, retired at the end of April after 16 years of state service. So we've recently announced Billy Meyer, coming out of our dry cleaning program, is going to replace Bill as the section chief. And we also welcome Tracy Wall. She's going to be working out west, but heading our Brownfields program up as the new section chief for that program. So two pretty critical changes for our division with two new section chiefs in the last couple of months. We are preparing for a large community meeting next week down in Baden, North Carolina. That's Stanley County, the former Alcoa site, aluminum smelting site that's been closed for quite a few years. We have a RCRA hazardous waste permit that's up for renewal on that site. A lot of interest from community stakeholders, Duke University Law Center, Yadkin River Keeper, and a host of other stakeholders that we've been engaged with, and look forward to that discussion on that proposed hazardous waste permit renewal for that site. So appreciate all the collective work on that front. In addition to that particular Alcoa site, we continue to work on the Pactive Evergreen site we've updated the commission on in Canton, North Carolina. A lot of great work going on up there between our Brownfields program and our Inactive Hazardous Sites program. We're at the final stages of finalizing an administrative agreement to oversee the additional assessment and remedial work up there that relates to the Pigeon River. So really excited about the progress with that site. In addition to these areas, we've also been working with the UNC Collaboratory, as we've mentioned to the commission briefly, on 6 fire stations across North Carolina where the Collaboratory sampled those rural fire stations for aqueous film forming foam, which has been known to potentially contain PFAS. We've sent sampling teams out to Guilford County, Wake County, Stokes County, Rowan, and Alamance County to sample private wells around these rural fire stations. We've sampled about 250 private residential drinking water wells thus far. Almost half of them, unfortunately, have PFAS detections in groundwater that warrant follow-up. So more to come on that front. A lot of great collaboration thus far, collaboratory with communities, local municipalities, et cetera, but more to come there. And I did want to conclude by recognizing 2 of our Helene response teams. DEQ acknowledged the waste management, solid waste, Helene debris management team. They approve all of the temporary debris sites related to Helene, so that the vegetative, construction, demolition, and other materials can be managed after a significant storm event like Helene. They got acknowledged last week along with our UST Bridge Loan Program. So both of these teams have done fabulous work. The General Assembly allocated $22 million to Division of Waste Management to provide loans to gas station owners that were impacted by Helene. Brand new program for us. We had to create loan documents, loan requirements, become basically very familiar with banking regs in order to facilitate this. But proud of both of those teams and the great work they've done and the recognition they received. That's it, Mr. Chairman. Thank you.
Director Scott, any questions for Director Scott? Very
Thanks.
good, thank you. Director Rogers.
Thank you, Mr. Chair, members of the commission. Just wanted to highlight a few things in the director's comments, provided you updates again on Helene projects that are ongoing in our water treatment facilities and wastewater treatment facilities. You'll see that most is no change. Continue to work on them. A couple of highlights is the Elk River has its package plan in place, and hopefully it'll be online May 18th. We also have power installed at Hot Springs in order to get that package plant moving forward as well. Just last week, we received news from EPA. They've approved the latest triennial review that y'all processed. The main component of that was the E. coli standard that we adopted. So we have done that. Also, just concluded public hearings on a couple items, PFAS and 1,4-dioxane. We certainly appreciate the commissioners that were hearing officers and your great work that you did at those hearings. We'll be in the process of beginning to compile comments. Obviously, comments are open until June 15th for both of those rules, and we look forward to continuing on in that process. Let's see. Director Evans, look forward to working with you on the Laserfish Challenge. We're going to bring you on in and figure it all out. That has been a challenge, and we do appreciate your support on that, and we'll look forward to getting with you on that as well. The only other thing I want to mention is that I believe last week was Employee Appreciation Week. As always, appreciate all the work that our DWR staff do for the citizens of North Carolina, for this commission, and we certainly appreciate the great work they do, and a big shout out to them. Thank you.
Just a comment too, just thank you too. I mean, we laugh about the Laserfish stuff, but we had a problem a few years ago with expenses being paid on time. You've made the minutes a lot better. I know those sound like little things, but for a big group of people that's got a lot to do, those little things are very helpful. So we appreciate.
We understand. I think we all get a little frustrated with Laserfish every now and again.
We do. Commissioner Baumgartner.
Director Rogers and Evans, OneDrive is a wonderful thing, by the way.
We have that too, don't we?
I
We have it
agree.
on our 365, don't we?
People have to keep up with their passwords. That's the challenge.
That is the challenge, isn't it? Yes, we got emails.
Any comments on the 1.1 million gallon spill at Briar Creek? That's probably new news for you.
Yeah, it is new news, and I believe from what we've heard, it is contained. There was actually a spill into surface waters as related when they were trying to clean up the spill. I'm not sure about the details of that, and don't really have any additional information other than what we've heard in the news on that.
Thank you.
Thank you.
Director Abruzescus.
Thank you, and good afternoon, everyone. So it's budget season at the General Assembly, and so that reminds me that to share with you that our division's highest priority right now is to obtain revenue replacement for the forthcoming cutback of the Vehicle Emissions Inspection and Maintenance Program. This particular program is administered by DMV, but a portion of the revenues from those inspections come to the Division of Air Quality for administering the air quality program. So it can be used, the funds can be used broadly in our division, and they are used for permitting, compliance, monitoring, management, et cetera. 16.2 FTEs are supported by this revenue stream that will pretty much go away for the most part as this system, or as this emissions inspection and maintenance program off ramps later this year. So seeking revenue replacement for that part of our overall revenues is our top priority. A close second to that is also pursuing changes to our non-Title V permit fees, which were set in 1994 at the statutory maximums. So statutory and the lawmaking is necessary to change those fees. One example is the permit application fee for a small air quality permit right now is $50. So we'll just leave it at that. So that's the top two priorities for our division right now. Significant concerns beyond that, because that's been the anticipated, and we've been working on that for over a year, 2 years, trying to get those two things shored up. Unexpected things on the budget front include the 2027 federal fiscal year 2027 president's budget, which zeroes out our recurring Clean Air Act grants, which represent about 12% of our budget. Also zeroes out other media program grants as well from some of the divisions you've heard from already today. So that is also now a new priority on the table to convince Congress to restore and continue that funding in federal fiscal year 27, critical to our overall program. All right, so moving beyond that, you've heard earlier today, our rule readoption process is underway. We heard loud and clear at the March AQC meeting, get on with it. So we did that day, instructed staff to be positioned to come back to the committee with our Group 1 set of rules in July as an action item. So we have announced, and those on the AQC have received the announcement, but all of you have now are receiving the announcement that we're having our first stakeholder meeting on that Group 1 set of rules next Thursday at 2 p.m. Everyone's welcome to attend. There's a link in my written remarks online if you'd like to log into that or come in person. This is the same format we followed in the first round of readoption. I think it was a best practice to hear from everyone, share what little things that we've identified that need to be cleaned up along the way. And so Group 1 includes, all the most basic rules, our definitions and references and sources and emergencies. And you heard about ambient air quality standards earlier today, conformity and special orders. It's a group of rules that I expect to move very, very quickly and probably will have very little input and feedback on, but we're going to provide that opportunity and listen, importantly, in that stakeholder meeting next week. And then finally, just want to announce, and please join me in congratulating Katie Quinlan, who's here today. She was named our new planning section chief for the now retired Randy Strait, who retired back in April. Katie's no stranger to the commission. She has frequently presented to all of you, especially at the AQC and the full commission. She started with our division in 2019 as an engineer. Later became engineering supervisor of our rules branch, and later became acting planning section chief earlier this year, and now named permanent planning section chief. She's also received our department's Distinguished Employee Award in 2023 for her work on some of the most complex regulatory actions that our division has worked on or we're working on at that time. Prior to joining the division, she worked for the Texas Commission on Environmental Quality in their air division, writing air quality permits for a number of years. So we're super excited to have Katie in that role, and you will continue to see her in her new role here at the commission. That's all I have today. Thank you.
Thank you. Any questions for Director Abrazinskis? Again, thank you. And I'd like to thank all the directors again. I know those director comments take a lot of work and there's some edits and all that, but again, I say it over and over, they're brief, they're concise, and they are not only a huge benefit for this commission, but I believe they're a huge benefit for the public too. So thank you very much for that effort you put into those director comments. Little reverse order. Let me go to council. You have anything to add from this? We'll go around the horseshoe. Nothing? Director Evans, Executive Director Evans, I guess that's a mouthful. Judge, what do you got? Anything from a support staff standpoint? No? Okay. Commissioner Bailey, anything to add today?
Just wanted to note that I was the hearing officer at the PFAS hearing in Wilmington on April 23rd. There's a great deal of interest there, of course, and there was a lot of public participation. The hearing room held 175 people, I believe, and the fire marshal wasn't letting anybody else in unless somebody else left. And we also had about 65 people providing comments at the hearing. So I just wanted to thank the whole community there for their participation, as well as the water quality people who helped put together the hearing and made it a success. So thank you, everyone, for your participation and for facilitating such a good public hearing so that people could make their comments heard.
Very good. Thank you. Commissioner Bumgarner.
Yes, sir. Groundwater Waste Management Committee met yesterday. We had a rules review for 13A, 13B, and 13C passed through committee, which will be ended up at the EMC before probably next round in July. We had a rule readoption for O2S rules for a dry cleaning cleanup fund, which passed committee as well, and had some pretty good discussion on IMAX. We'll continue to have a discussion on IMAX most likely in July, and we'll continue on in September. That's all I got.
Very good. Commissioner Chmielewski, go ahead. I'm sorry.
Nothing to add, just good to continue to learn and work with fellow commissioners and the department.
Thank you. Commissioner Ellison.
Relatively uneventful air quality committee meeting yesterday. Look forward to working with the department to reconcile some of the petition versus the bundle of rules and figuring out that path. I was the hearing officer for the 1,4-dioxane hearing in Greensboro the other night, and probably very similar to what you heard in Wilmington and I don't know about Hickory, but with the exception of folks from the city of Greensboro, there were 3 of them who commented that basically said monitoring and minimization works. I know there's a lot of people that doubt that, and their system is a little different than what we have out on the street currently. But they had the receipts. They have cost analyses for different treatment technologies. They have results from working with their SIUs on the minimization plans and implementing those minimization plans. Tremendous success story. Don't hold me to the number, but I think it was a 97% reduction in their discharge from working on monitoring to find out where the problems were and minimization to tidy things up.
Thank you, Commissioner Ellison. Commissioner Hardison.
I really don't have anything to add, but to say thank you to all the divisions of DEQ and all that they do, all the work that they do. We're very grateful, and we know that it's a lot, and y'all tackle a lot and juggle a lot. So thank you.
Mr. Jespers.
Yeah, reiterating thank yous to the DEQ. I was the hearing officer for 1,4-dioxane in Fayetteville. It was a great experience. Never done anything like that. Having the gavel sitting right in front of me felt very empowering, not gonna lie. But it was really refreshing to see the sort of public and community involvement. They really care about what we do. And it wasn't quite as full as Wilmington, but it was still very engaging and very lively. So greatly appreciate the opportunity and really value everything that DEQ did to make this run smoothly. So thank you.
Very good. Commissioner Keen.
First of all, Mr. Chair, I'll make it short. It won't be 4.5 hours, but I will sum up. First of all, thank you, Dr. J, for sitting next to me today. She was very anxious to get away yesterday. Yes, sir. I
Yes, sir.
apologize many times.
We're making him stay on time.
I think Reardon was too now. We gotta watch
Very
that.
much so, sir. I apologize to both many times before and after I left. So thank you again. But summarize that Water Quality Committee meeting yesterday. I want to thank all that participated, stayed for all the information items that we had. Particularly too, I want to, I guess, call out would be the animal feeding operations, the general permits, rulemaking, and the rural readoption piece on agriculture. I'm thankful that the committee has 2 ag appointments. Those appointments came from North Carolina Agriculture Commissioner Steve Troxler. And he was here yesterday to sit in on this information item. There was a lot said, Mr. Chairman, committee commissioners, that will be an ongoing piece of information and moving forward through the process on ag. But the 2 appointments that we have with Joe Reardon and Bill Yarborough certainly bring a lot, just so much information on agriculture. And as chair, I appreciate that. The second piece would be the stormwater. We had conversation and information and concerns. And at the end of the day, it was I appointed 3 committee members to be a stakeholder working group to work along with our executive director, John Evans. And those 3 are Commissioner Ellison, Commissioner Twitty, and Commissioner Baumgartner, to work again in concert with the department and structure a path forward of how we get through this stormwater piece. But with that, that's all I have, Mr. Chairman. Thank you.
Commissioner Zavaletto.
You're getting closer, kid.
I am. Tired though, you can tell.
No, I just, again, want to thank the department and all the staff. Really appreciate all of your efforts and the information that you share. It's good to see everyone. Hope you all have safe travels and leave it at that.
Very good. Thank you. Commissioner Smith.
So, there are some things in the rulemaking process specifically going through committee that we need to work on. And Commissioner Orm Zavaleta yesterday raised one of those issues and never got a clear answer to what is our process for bringing rule drafts for discussion in committee, and whether that should come before or after there's a regulatory impact analysis. I was listening to the committee online yesterday after I left here, and I would have to say it was somewhat dispiriting experience. We have some commission members who are criticizing the staff for not bringing rules to committee until after there's an approved RIA. We have committee chairs who are refusing to put rules on the committee agenda until after there's an approved RIA. We need to reach some common understanding of what this process is, to be fair to the staff and to the other commission members and what they can expect. Now, I have my preferences. I think we ought to be working on the rule drafts more in committee before there's an RIA, but that's my personal opinion. I think we should stop keeping things off the agenda or then putting them on only as information items and appointing a subgroup of the committee to work on them instead of having the committee do that work. So we've got some big issues about how rules are going through committee, and it's creating a lot of unnecessary stress and frustration, especially when the staff is getting beaten up from both sides, but when they're doing what they've been told to do, asked to do. So I'd start with the RIA issue. We need to decide, do we want to see rule drafts and draft RIAs before they go to the Office of State Budget and Management or not? And then do it, and do it consistently. Because the process now is just really, the committees are not functioning as committees. They're just not. Everything on the agenda of the Water Quality Committee yesterday just about was another information item, including the stormwater rules, which could have been discussed at any time by the committee since last November. They were still an information item yesterday. We need to make the committees function. And I don't know what the issue is. I don't know if people don't want to work on rules in committee, if it feels like it gets out of control, if the committee actually works on rules, but the committees are not functioning. Some of them are better than others, but the ones with the most controversial rules tend to be functioning the worst at the moment. And we need to straighten some of that out. Thank you.
Very good. We all have our opinions and we'll work on it.
Yes, we do.
Commissioner Tweedy.
The Water Allocation Committee met yesterday. We had one action item. Director Vincent already covered it. It was the dam safety O2K rule readoptions. I want to commend the staff for putting together a very good first draft of that rule and then working with the committee through a couple iterations to make sure we had that language as tight as we possibly could. So thank you all for working with us, and I think everybody's happy with it. So that'll be coming to EMC in July. Two information items. One was on drought condition. I believe North Carolina is all pretty much in severe or extreme drought right now. So if you're a religious person, throw up a few prayers. If you're not religious, maybe throw up a few too, just in case. We had an IBT update. Mooresville and Charlotte are working on their EISs. So we're kind of in a holding pattern as far as a committee on those. Fuquay-Varina, the EIS has had its public meetings. We've received comments. That comment period is closed. Department is working on response to comments and hearing officer report on that. So that'll be coming back later this year, I'll just say. So I probably wouldn't have said some things the way Robin did, but I agree with the sentiment that I personally can express some confusion on the process as well. And I agree with her. I think we do need to map out the process by which we're working on rules in committee so that it is clear to the department. I've been frustrated. I can sense their frustration as well. And I don't feel like they're getting a consistent message because I don't feel like I've gotten a consistent message. So if I'm not getting it, I don't think they are either. So, but I do think it's something we can definitely work on in short order, maybe with Director's help over there. Thank you.
Thank you, Mr. Tweedy. Commissioner Wright.
So I was the hearing officer for the 1-4 Dioxane hearing in Hickory, and it went much like others have described their hearings. It was well attended, probably better attended by the general public than I expected, and less so by the regulated community. In that area, I really expected, several POTWs to be represented, and that just was not the case. Comments went similarly as well. Thank the city of Greensboro for attending that public hearing too and commenting. So by and large, the hearing went well. Thanks to DEQ staff. You did a great job for selecting the venue, administering the hearing, making sure everything went smoothly. So again, thank you.
Very good. Mr. Yarborough.
Yeah, I was a hearing officer in Asheville for PFAS, and I commend the staff for what they did. They made everything very pleasant, and it was for an unpleasant experience in a way, but there was a lot of different things. We didn't have the numbers that I expected out of Asheville, but there was a significant. So you did great work and appreciate that. That was on April 6th. The law says I have the right to remain silent, and I'm going to use that right now I've spent enough time talking today.
Very good. Vice Chair Reardon, any comments today?
Not really. Just thank the department for all the hard work in these very tough issues, but extremely important to the citizens of this state. So thank all the committee members around here. Executive Director, thank you for your presentation on 1,4 dioxane and also some on PFAS as well as we take on that body of work. Thank everybody for the work. That's it.
So first thing I want to do is thank commissioners for serving as hearing officers. It's always a challenge as you add new members and time goes by and you try to get the bench strength a little deeper, and then you think you've done a few maybe small ones and you step in some big ones, and it's really tough. But I appreciate 6 or 7 of you have had some tough ones to do. But that's good seasoning and that's good experience, and that gets our bench strength really deep for going out and do more of these. So I appreciate it. I'll also add this, and Commissioner Jaspers mentioned this. Those public hearings and the petition for rulemaking like we heard today, and the declaratory rulemaking and the civil remissions like we're going to do this afternoon, those are the big contact points with the public. And they were so important that we carry ourselves well and come across well. And I think we just need to appreciate that every time. It feels like a very insider game to the outside public, right? But that is where we're really with the public and can really hear and listen and give the right perception. So I appreciate the professionalism y'all do when you do those things and the importance of all those. Decision that I've made, and you'll have to trust me on this because some of you are not going to like it, but I've talked to both chairs and they're in agreement. We were sending the river basin plans over to water allocation to try to relieve water quality. I decided last week that I wanted to move it back to water quality committee. It's to do with timing, and you have to trust me beyond that. But it is a big report, and there's a lot of timing issues around it. So we have talked about that. So I'm going to move it there. I will say this: I heard some things yesterday that would tell me we may have to have a few more meetings or some meetings between meetings. I hate to say we did that back in 17 or when the coal ash was here. We met every month because it was just that big a load. And it feels like some of the things I heard yesterday that we're going to have a really big load coming in here, and we may need input of the whole commission on a few things. So I don't have any ideas. I'd hate to do that over the summer, but I'm just saying be prepared because there is a lot of work that seems to be piling up on us. And so I hope that our new executive director and the staff that we're working on getting hired will take some of that load off us as volunteers and keep us more in the decision-making mode. But with that said, it's still going to take some input from these capable commissioners to make sure we're in the right direction. So with that said, thank you guys. Been a good meeting. I appreciate everything y'all have done the last couple of days and all that you continue to do. So we're adjourned. Remissions will go off at, can we say 1 o'clock even? 1 o'clock even? Okay.